Total 9.
ನಾವು ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡ್ಕೋಬೇಕು.
Mentionings from video. Any mentionings from video? Yes, memos from the left.
Serial number 20, my lords. My lords, serial number 20.
Day after tomorrow. Yes. Monday. Yes, next.
My lord, this is 138 proceedings. My lord, this court had allowed IA, my lord, stating that subject to conditions of depositing 40% of fine amount. My lord, the petitioner, my lord, had given money to the council, my lord, lower court council. Council had misused the money. We have filed complaint, my lord, in the bar council. Also, transactions made online is also given, my lord. Now, my lord, by file addition, IA sought time for extension of time to pay the fine amount. My lord.
Tuesday. Monday. Monday.
Extension of time for to deposit the amount because by mobilizing.
Mention is.
Please, my lord, serial number 51. Monday it was posted, please, my lord. I requested this court to kindly have it on Monday. And I informed the petitioner counsel also that matter would be listed on 30th. I mistook that it will be called on 30th of Monday, but today it is listed. I kindly have it on Monday. We are ready. We will argue on Monday. We don't take any more adjournment on that day, please.
Serial number
51, please, my lord. Monday it was listed, please, my lord.
From Monday it has come today.
From Monday to Wednesday it has come.
So proceed with the matter, please. 23 it had come.
Monday we will argue the matter, please, my lord. Just 3 days accommodation we are asking.
So 11 years accommodation you have been granted.
No, please.
11 years.
Now I come on record on the
That
law.
is not an excuse. That can never be an excuse.
We
Matter
wanted,
is of the year 2011. I do not know of which year.
of course.
That will be further older.
Just 3 days time, please, my lord. My submission may kindly be recorded. 3 days, please, my lord. Monday, please.
Petitioner has a final last chance. Today's accommodation as prayed is granted, making it very clear that no further adjournment for any reason whatsoever may be would be granted on the next date of hearing. In case if both sides to proceed further in this matter on the said day, the court will proceed to pass appropriate order. List the matter on the top of the list on 35/2022 as prayed. Yes.
Serial number 46, Milan. May kindly be have it on first.
33 or something somebody said. 27. But there is an IA for permission. We'll see what that IA is. Why adjournment?
I'll formal objections to that.
Whom you appear for?
I appear for the petition.
IA filed by whom?
Impeding applicant for assisting the prosecution, the IA has been filed.
For the petitioner, prays for a short accommodation. Stating that he would like to file his objections to IA 1/2021 as a final last opportunity. Short accommodation as prayed is granted. This matter on 1/6. Yes.
Serial number 46, Milan.
46.
It may kindly be have it on 1st June, Milan.
At the request of the Learned Counsel for the petition.
46.
This matter in the next week. Yes.
Please.
29, my lord. 29 serial number. Appear for the petition, my lord.
Yes.
My senior is out of town, my lord, to attend a family wedding. I pray
Now
for
we'll see when the matter reaches. It's a series of matters are there. Make a submission, the matter reaches, we'll see the order sheet.
Serial number 32 here.
Yes.
Checkpoints case here. There is a amicable chances of settlement here. Another case is pending here. Case here.
At the request of the Learned Counsel, whom you appear for?
For petition.
The petitioner who submits that the settlement process is going on as a final last opportunity, a week's time is granted either to report settlement or to proceed further in the matter. Yes.
Your Lordship, serial number 43, Your Lordship.
Yes.
I am for the petitioner.
Yes.
Really 138 proceedings. So
Yes.
out of the same complaint, ಇನ್ನೊಂದು criminal revision petition file ಮಾಡಿದ್ರು. There are 2 criminal revision petitions. Criminal revision
Check
224.
ಬೇರೆ ಬೇರೆ ಅಲ್ವೇ?
Your Lordship.
Check bounce case.
ಹೌದು ಸ್ವಾಮಿ. Check bounce case.
Checks are different.
ಇಲ್ಲ same proceedings. ಅದೇನಾಗಿದೆ appeal ಅಲ್ಲಿ the respondent also will file an appeal. I will also file an appeal. Conviction ಆಗುತ್ತೆ. Respondent will file an appeal for more enhancement ಗೆ ನಾವು ಒಂದು ಹಾಕ್ತಿವಿ. ಅವ್ರದ್ದು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತೆ, ನಮ್ದು ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ಅಗೇನ್ಸ್ಟ್ ದಟ್ 2 ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಸೊ ಇನ್ನೊಂದು ಬಂದಿಲ್ಲ ಇವತ್ತು, ಕ್ರಿಮಿನಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ 224 of 2022. ದಟ್ ಇಸ್ ದ ಮೈನ್ ಪಿಟಿಷನ್. ಅದರಲ್ಲಿ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಕೇಳಿದ್ದೀನಿ. ಸೊ 2
43 serial number.
Yes, your lordship.
Counsel for the petitioner submits that arising out of the same order, one more petition bearing criminal revision petition number
224 of 2022.
224 of 2022 has been filed by him and which are required to be listed along with the present petition. Registry to verify the same and do the needful, list the matter in the next week. Yes.
Obliged.
Yes. Yes. Settlement, otherwise the matter would be proceeded. ಹಿಂದ್ಗಡೆ ಒಂದು ಹಾಕಿದ್ದೀರಿ ನೋಡಿ, 1 week. Yes. Yes. No, we will see when the matter reaches. There are an IAS in that matter. Yes. Call the case, please. Yes, please. Yes, please. ಹೇಳಿ ಏನು ಆಟೋಮೆಟಿಕ್ ಪೋಸ್ಟಿಂಗ್ ಆಗಲ್ವೇ? ಅದು 5th ಡೇನೋ 4th ಡೇನೋ ಏನೋ ಬಂದು ಹೋಗಿದೆ. ಬಂದು ಹೋಗಿ ಮತ್ತೆ ಈಗ ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆ?
Suspension of sentence.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಯಾಕೆ ನೀವು ಬರಲಿಲ್ಲ?
Office objection.
ಈಗ ನೀವು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು, ಮಾಡಿ ಆಗಿದೆಯಾ? ಮಾಡಿ ಆಗಿದೆ. Yes, Tuesday. Provided all office objections are complied with. Yes. What? ಸ್ವಲ್ಪ ಗಟ್ಟಿ ಹೇಳ್ಬೇಕ್ರಿ.
46, my lord. It is urgent for next week, my lord.
ಅದು ಆಲ್ರೆಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಆಗಿದೆ. ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ನೀವು ಹಾಕ್ಬೇಕಾಗ್ತದೆ ಇದಕ್ಕೆ.
I saw time on behalf of the petitioner.
ಹಾ, ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಆಗುತ್ತೆ.
Also file objections to the delivery.
46.
ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನ ತೆಗೆದು ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅಂತ ಮಾಡಿ. ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಹಾಕಿಸ್ಕೊಳ್ರಿ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ.
Madam, my understanding is that discussion also for local, not the state.
Number 1 to 6 as finally 1 week time is met. Then appear as a final opportunity, 2 days time is granted. In case the office subjects are not completed within 2 days, list this matter. On. More. Yes.
Thank you.
1 week time may be granted for the office objections. Last time during the COVID days, it has come. Periodically, then we tried to move memo for this, your lordship, but matter was not listed.
Final opportunity, 1 week time is granted, making it clear that no further adjournment is could be granted. In case the office objections are not complied with, list this matter on 3/6. Yes.
My lord, I pray for weeks time.
Same order, 3/6. Law finally.
My lord, I pray for weeks time in this.
Finally, 1 week, 3/6. None appear in this matter, either physically or through video conference. No reasons are forthcoming for non-appearance of the learned counsel for the petitioner in the matter. Perusal of the order sheet would go to show that in this petition of the year 2020, in spite of granting several insufficient opportunities of not less than 4 times, even as finally also the petitioner has not completed the office objection. He has not even shown the reason for non-compliance of office objection. Hence, the petition stands to dismiss it for complaint of office objection as well as for non-prosecution.
I am for the petitioner in this case, my lord. Finally, a week's time may be granted, my lord. I'll comply the office objections, my lord.
At the request of the learned counsel for the petitioner, as a final last chance, 3 days time is granted to complete
Please.
office objection. In case the office objections are not completed within the set time, which is needed on 31/5, on which day the court may proceed was appropriate order.
I appear for appellant, my lord. Last date, my lord. Certificate of art. You took to file the certificate of art today.
At the request of the learned CGPA, days accommodation is granted to carry out the permitted amendment in the memorandum of appeal / revision petition. List the matter on 31/5. Learned HCGP present, none appear corresponding.
For respondent, number 40.
When appear in this matter, either physically or through video conference. No reasons are forthcoming for non-appearance of learned counsel from either side in this matter. Subsequent to the direction given to the registry by the order dated 24/5/2022, the registry has clarified that no records in criminal appeal 571/2011 has been received by the registry of this court, except the letters mentioned by the lower appellate court. It has also reiterated that under the letter number CRR TO number 93/21 dated 16/4/2021, it is submitted that records in criminal appeal 571/2011 have been destroyed on 9/12/2019. Next slide. It is noticed that in several of the matters, including ನಿನ್ನೆದು ಮೊನ್ನೆದು 4 ನಂಬರ್ಗಳು ಇದೆ ನೋಡಿ, destroyed ಅಂತಿರೋದು ಅದನ್ನ ಹಾಕಿ so it has been intimated to this court with the respective trial oblique sessions court that the records called for by this court in those matters have been destroyed by them. Probably the same would happen for the reason that even after filing of the criminal revision petition or the appeals, there would be enormous delay in calling for lower court records, calling for trial court oblique sessions court records, by which time, as per the prevailing rules, those courts would proceed further in destroying the records. In such an event, it would be very difficult for the court to proceed further in the matter, and a laborious exercise of building up of records has to be undertaken by the court or the registry. That too is not sure that the built up record would be complete in itself. Thus, to avoid any such inconvenience which is being repeatedly caused in any revision petition, criminal revision petition, civil appeals, criminal appeals, etc., it is advisable if the concerned trial court of the district court or the sessions court are intimated immediately after filing of any revision petition or appeal, bracket, civil and oblique or criminal, comma, before this court, comma, about filing of such a revision or appeal, so that the concerned trial court or the district or sessions court would not proceed further to destroy the record without hearing further instruction by this court in the matter. To do the same, the simple procedure, the registry may have to be adopted like immediately after filing of revisions or appeals, bracket, similar and oblique or criminal, comma, an auto-generated email oblique intimation is required to be sent to the concerned trial court as well as to the district and session judges court from the order of which court the appeal or revision has been preferred. Invariably, such an intimation is also recommendable to be sent even to the office of the district court, which would be at the helm of the affairs in the particular district. In that regard, the suggestion of the computer section here was also solicited by me on 24/5/2022 in the evening, and they also opined that such a facility can be enabled easily without any additional burden. Therefore, the Registrar General is hereby directed to secure necessary orders, if required, by the Honorable Chief Justice of this court, and issue and make necessary arrangement to ensure that immediately after filing of any revision, review, appeal, etc., bracketnally, civil and oblique or criminal, before this court, before the matter could proceed to any further stage, including scrutiny, an auto-generated email and oblique or intimation be sent to the concerned court, from the order of which the appeal or revision or review has been preferred. A copy of the same also be sent to the concerned, sent to the district court of the concerned district for their information and needful in the matter. The said facility be extended to all pending matters in which the records are yet to be called for. Again, the said facility, apart from being provided to the matters that are going to be filed afresh, be also extended to the pending matters where the lower court records are yet to be called. In the meantime, the registry to forthwith issue a circular to all the courts below. So, in the meantime, the necessary arrangement or the software development to be made and the above direction to be implemented within 4 weeks from today. In the meantime, the registry to issue a circular to all the trial courts, district courts, tribunals, labor court, etc., coming under the supervision of this court, to defer in destroying of the records for a period of 4 weeks from today or till the necessary software development and its implementation is effected by the registry as directed above. Next line. In the instant case, the learned Registrar General to submit formalities to be undertaken in building up the records afresh. List the matter. 1/6/2020.
Non-bailable warrant was issued against the petitioner.
Yes.
But, on last occasion, non-bailable warrant was issued against the petitioner. We have filed a report yesterday. It was not yet put. Tried to trace him, my lord, in the same address, it was not found, my lord. Seeking a 15 days time to fulfill the petition.
No, if they are unable to trace him, say I will summon the IG of the police. Let him know that how inefficient officers are there in his department.
At address, they could not find him, my lord. They filed-
ಬಾರ್ಡರ್ ಅಕ್ಯೂಸ್ ನವ್ರನ್ನ ಹಿಡಿಲಿಕ್ಕಾಗಲ್ಲ, ಅವ್ರ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಷ್ಟು ವೀಕ್ ಇದೆ, ಇನ್ಎಫಿಷಿಯಂಟ್ ಇದೆ ಅಂದ್ರೆ ವಿಲ್ ಮೇಕ್ ಎ ಜುಡಿಷಿಯಲ್ ಅಬ್ಸರ್ವೇಷನ್ ಇನ್ ದಿ ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಜನರಲ್ ಆಫ್ ಪೊಲೀಸ್. How many percentage of NBWs are being executed promptly by the police? Have you conducted any survey? That would not exceed more than 27%. In 73%, they come up with some excuse for non-executing. It is also told that in many of the matters, they do not make any attempt at all to search. Some constable would be asked to find that person, that constable, along with the writer sitting in the police station, writes that the person, his house was visited, the person is not available, he has already left the address. Majority of the police constables send their time near dhaba, canteen, other shops where they get free lunch, meal or breakfast, including the traffic inspectors. This is their department style of work.
Inspector of that police station is.
ಏನು ಉಪಯೋಗ ಇಲ್ಲ. I summon Inspector General.
10 days.
I will recommend his name for Presidential Medal for non-tracing an accused. ಎಲ್ಲ ಹೇಳಿ. Now the police department has become a stock of comedy in any serials, movies, etc. To such a level, their dignity has come down. Because of their letharginous inefficiency, finding out only false excuses, twisting the fact and the law, misusing the power. Whom you appear for?
Appellant, my lordship.
Yes. Why did you not appear earlier?
Last occasion we appeared late, my lordship. That's why. Similar matter already disposed, my lordship. This is 1040 same offense. ಎರಡು ಮನೆಯಲ್ಲಿ theft ಆಗಿದೆ. ಒಂದು ಇದು ಇನ್ನೊಂದು 1040 already disposed of.
That is not an excuse for your absence.
Yes, my lordship. I apologize for that.
A mere apology won't do. Say you should repent that, say you have not assisted the court and contributed in delay of this matter of the year 2009. For 13 years, what faith the general public would have? ಒಂದು ಆರ್ಡಿನರಿ ಒಂದು ಮನೆಯಲ್ಲಿ ಒಂದು ಸಣ್ಣ ಕಳತನ ಆದ್ರೂ ಕೂಡ ಅದು ಕೇಸು ಅನ್ನೋದು 15 ವರ್ಷ ಆದ್ರೂ ಮುಗಿಯಲ್ಲ, 20 ವರ್ಷ ಆದ್ರೂ ಮುಗಿಯಲ್ಲ ಅಂದ್ರೆ that is the reason why the common people are losing their confidence both in the police as well as in the judiciary. They go for private people. ಏನೋ ಒಂದು ಮಾಡಿಸಿ ಬಿಡ್ರಣ, ಬೇಕಾದ್ರೆ ದುಡ್ಡು ಖರ್ಚಾಗ್ಲಿ, ಏನೋ ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ರಿ. ಆ ಪರಿಸ್ಥಿತಿಗೆ ಬಂದಿದೆ ಈಗ. 15 ನಿಮಿಷದ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಎಷ್ಟು ವರ್ಷಗಳು ಎಳಿಲಿಕ್ಕೆ ಸಾಧ್ಯವೋ ಎಳಿತೀರಿ. 2012 ಮ್ಯಾಟರ್ 10 ವರ್ಷ ಪೆಂಡಿಂಗ್, ಒಂದು ರಿವಿಷನ್ ಪಿಟಿಷನ್. I will take up the matter by 2:30. You are proceeding with the matter.
Yes, happy money for the petitioner, government leader, for the respondent. In this case also, my lord, NPW was issued.
What's the reason for its non-execution?
It was not found in that village, exact village.
Now they obtained the report of the Gram Panchayat secretary.
My lord. They obtained
They have obtained. Can the Tahsildar certify that a particular person is not residing in a village? What is the local Gram Panchayat has stated? Please call the report. No case for the petitioner in this matter. I would like to proceed further in securing the presence of the petitioner. What is your further submission in the matter? Looking to the legal aspect, what you are required to do further and make a submission at 2:30 p.m. The learned counsel for the petitioner not present, learned HCGP for the respondent alone present. NBW report. ಈಗ ಫ್ರೆಶ್ ಹಾಕಿದೆ. ಅವರ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿ ಇದೆ? ಇದು ನಾವು ಕೊಟ್ಟಿರೋದು ಅವರ ರಿಪೋರ್ಟ್. ಈ ವಾರೆಂಟ್ ಅವರ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿ? Don't we? GP? The report regarding the execution or not of the non-available warrant is yet to be filed. The Learned HCGP submits that the same has been submitted to her by the concerned police only yesterday evening. The matter is passed over to enable her to file the same. Call the matter at 2:30 p.m. Yes. Ask him to see. Ask him to see. There is a procedure. If such a report is filed in the registry to place the same before the court at 2:30 p.m. today, along with its explanation for not placing the same today when the matter is taken up. Yes. Along with the explanation by the registrar judicial. Yes. None appear for petitioner in this matter, either physically or through video conference. Petitioners no Sri. Both the petitioners were called out, they have remained absent. The Learned HCGP for the respondent alone present. ನೀವೇನ್ ಕೂಗಿಸ್ತೀರಿ ಅದು ನಿಮಗ್ ಮಾತ್ರ ಕೇಳಲಿಕ್ಕಲ್ಲ, ಅದು ಇಡೀ ಪ್ರಪಂಚಕ್ಕೆ ಕೇಳಬೇಕು. ಯಾರ್ಯಾರು ಇಲ್ಲಿ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಕೇಳ್ತಾ ಕೂತಿರ್ತಾರೋ ಅವ್ರೆಲ್ರಿಗೂ ಕೇಳಬೇಕು. ಎಲ್ಲ ಔಪಚಾರಿಕವಾಗಿ ಅಲ್ಲ ಮಾಡೋದು, ಅರ್ಥಬದ್ಧವಾಗಿ ಮಾಡ್ಬೇಕು ಯಾವುದೇ ಕೆಲಸ ಆಗುತ್ತೆ. ಕೂಸಿ ನಮ್ಮ ಗಟ್ಟಿಯಾಗಿ.
ಶಂಕರ್ ನಾಯಕ, ಲೋಕನಾಯಕ, petitioners.
The perusal of the petition as well the order sheet would go to show that the present revision petition is of the year 2013. As such, one of the old such petition pending before this court. The criminal case is of the year 2008. As such, it's a 14 years old criminal matter. Next, the perusal of the order sheet would go to show that Learned advocate one Shri Mallikarjun Sri Basareddy was appearing for the petitioner in this matter. However, later it was reported to this court that said and counsel was appointed as government advocate and is serving at Kalburgi bench of this court. However, subsequent to thereafter, on 24/2022, it was further observed in the order sheet as below, extract. Thus, a duty is cast upon every advocate who has accepted and holding wakalat for their clients to intimate their respective client about their inability or disability, about their disability to proceed further in the matter representing the respective clients and intimating their clients about their intention to retire from the matter so that the clients would make alternate arrangements. Needless to say that merely because a person is appointed as a government advocate, his duty towards the court as an existing counsel for his clients would not cease. Rather, it would add an additional duty upon him to convince the court that he has duly intimated about his fresh assignment to his clients and had requested his client to make alternate arrangements, enabled his clients to make alternate arrangements in representing their case. Since said Sri Mallikarjun Basareddy, in view of his undertaking, which has been spelled out in the observation order dated 24/2022, has failed to do any such professional commitments in that regard, the court is put to inconvenience now in proceeding further in the matter. Let this observation be brought to the notice of the learned Advocate General of this court immediately by the registry. Next line. Issue emergent court notice to the petitioners, returnable by 13/6.
Satyanarayana SLK.
It is also not known, 13/6 Munche. It is also not known as to how come the registry has not shown the name of said advocate Mallikarjun Basareddy in the cause list. Needless to say that he has not, it appears that there is no judicial order to not to show his name. Till a counsel retires from any matter, his name is expected to be shown in the cause list. Learned registrar judicial to submit his written explanation, written submission in that regard, and also about the necessary action taken, if any, in that regard against the erring officials. Yes.
I appear for the petitioner, my lord. The respondent has been expired, my lord. The respondent counsel requested to furnish the details of the legal representatives of the deceased respondent, my lord. Even in the morning also, details of the legal representatives has not been provided. If 2 weeks time will be granted, like necessary application to bring the legal representatives on record.
Respondent date.
Yes, ma'am.
When he died?
But date is not mentioned, my lord. At the last occasion, the respondent counsel has made a submission to the court, my lord, saying that the respondent has been expired. Said that he will furnish the death certificate and the details of the legal representatives. The details has been furnished. I will file the necessary applications.
The counsel for the petitioner, who is physically present, submits that despite his instruction to the complainant to ascertain the details of the legal representatives of the deceased respondent, nothing has been heard from the complainant. Stating so, he requests for some more time. A perusal of the order sheet would go to show that long back the death of respondent has been reported to the court, and the petitioner has been already granted sufficient time to take necessary steps in bringing the legal representatives of the alleged deceased respondent on record. However, since the petitioner has not made any effort in that regard, by efflux of time, the revision petition as against the respondent stands abated. Yes.
For the respondent,
I am for the petitioner in this case, my lord. The matter is already settled, my lord. The check bones case is, check bones case, my lord. 20,000 is the check amount. The total fine amount is 5,000, 25,000 is the liability, my lord. The petitioner has deposited 15,000 before the trial court and 20,000 before this honorable court, my lord. So totally he has paid more than 25,000, my lord. 30,000, 35,000 he has paid, my lord. And for such, my lord, the last hearing date, my lord, this court has ordered to file an application, my lord. I have prepared the application and sent it to the petitioner, my lord. It is not come back, my lord. I pray for a week's time, my lord. I'll file that application.
To proceed with the matter, we will hear and dispose of on merit.
No, already settled, my lord. Amount is paid, my lord.
No, if it is settled, you should have reported the matter by this time. Unless the matter is reported to the court in a manner known to law,
Please, my lord.
it is deemed that the matter is still pending at the stage where it was.
Yes, my lord.
Proceed with the matter.
Kindly
Your
have
client
it.
is not interested in, say, expediting the matter. Let him suffer an order, whether it would be in his favor or not.
Please, my lord. Kindly have it on Monday, my lord. I'll file the application, my lord.
Counsel for the petitioner appearing through video conference reiterates its submission made earlier. Including the one dated 24/2022, stating that the matter has already been settled between the parties. However, as observed on 24/2022, no corresponding application to Section 147 NI Act has been filed by either side. Even thereafter, without even making any further submission or proceeding further in the matter, both sides remained absent on the next date of hearing. This made this court on 24/5/2022, on which date also learned counsel from both sides has remained absent, that failure on the part of the parties to proceed further in the matter would make this court to pass appropriate order. It is only when this court passes such an order, the learned counsel for the petitioner is appearing today. Yes, proceed with the matter now.
Please, my lord. I pray for 2 days time, my lord. I have already sent the application.
However, despite the above observations and the developments, the learned counsel for the petitioner is once again praying for some more time.
Respondent also,
in the criminal case, which is of the year 2007, thus 15 years old matter.
Please,
As such, granting of any further time would be only a cost payable by the petitioner to the legal services authority of this court. Accordingly, imposing a cost of ₹500 payable by the petitioner to the legal services committee and authority no Haki of this court within 2 days from today. 2 days time as prayed for is finally granted.
Friday, my lord.
Finally granted. The cost imposed to be a complaints memo along with receipt to be filed in the registry within 2 days from today. List this matter as the second topmost matter in the list on 30/5/2022. Yes.
I appeal for the petitioner, my lords. Kindly pray for a week's time, my lords, to comply with the PF and issuance of a copy of the petition, my lords.
₹200 per day cost. Maximum 7 days time. How many days you require?
My lords, I am very sorry, my lords.
₹25 ಕೊಡ್ಲಿಕ್ಕೆ ನಿಮಗೆ ಒಂದು ವಾರ ಟೈಮ್ ಬೇಕು. 3 ವರ್ಷ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇವೆ. 25 ರೂಪಾಯಿಗೆ 3 ವರ್ಷ ಟೈಮ್ ಕೊಟ್ಟರು, ಇನ್ನೂ ಒಂದು ವಾರ ಟೈಮ್ ಬೇಕು. ಇನ್ನೋವಾ ಕಾರಲ್ಲಿ ಕೂತಿದ್ದೀರಿ.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಾನು
ಕೊಡ್ಬೇಕಾದ್ರೆ ಟೈಮ್ ಬೇಕು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಟ್ಲೀಸ್ಟ್ ಒನ್ ಡೇ ಟೈಮ್
ರಿಜಿಸ್ಟ್ರೇಷನ್ ನಂಬರ್ 1 ಕಾಣ್ತಾ ಇಲ್ಲ.
ಸಾರಿ ಸ್ವಾಮಿ, ಒನ್ ಡೇ ಟೈಮ್ ಮೇ ಬಿ ಗಿವನ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಒನ್ ಡೇ ಟೈಮ್, only one day. I'm going to comply with that immediately.
Counsel for the revision petitioner appearance through video conference submits that to do the needful in the matter within a day from today.
Much obliged, my lords.
Final opportunity, a day's time as spread is granted. In case the needful is not done, registry to list the matter on 31/5. Yes, one day.
21 and Subramani.
Pray for 2 days time to do the needful.
The request of the learned counsel for the petitioner as finally 2 days time as spread is granted to do needful. In case the needful is not done within the set time, list the matter on 1/6.
22 in Prakash.
After securing the interim order of suspension of sentence, the petitioner appears to have forgotten that he is under an obligation to pay the necessary process and furnish copies in the registry to enable it to send a notice of this petition to the respondent hearing. No reasons are forthcoming for non-furnishing of PF and copy for issuance of notice to the respondents. Showing no reasons, the learned counsel for the petitioner also has remained absent. Hence, the petition stands dismissed for not taking steps as well as for non-prosecution.
Sridhara.
None appear as finally 3 days time is granted to do needful. In case the needful not done, registry to list this matter on 2/6.
Yes, Sachin.
When you have done needful? At 11 o'clock today.
10 o'clock.
10 o'clock. Good. 1 hour early. The counsel for the petitioner physically present and submit needful done today. Registry to verify and proceed further. If needful is not done, list this matter on 3/6.
Hearing on case number 25, Sidhunur Vishwanath.
This case, here the respondent filed the EMI. I prepared my objection, serve the copy and file the office. So the mainly adjourned for 2 weeks for hearing. 2 weeks. Inconvenience for 1 week, next week.
But 2 weeks time ಕೊಡ್ತಾನೆ. Every day 200 rupees. ಎಷ್ಟು ದಿವಸ ಬೇಕು?
Personal inconvenience ಇದೆ.
ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಮಾಡಿ.
Objection
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ, ಫೈಲ್ ಮಾಡಿ, we will proceed. ಈಗಿನ 22ನೇ ಶತಮಾನದಲ್ಲಿಯೂ ನೀವು ನಿಮ್ ಜೇಬ್ನಲ್ಲಿರೋ ಮೊಬೈಲ್ ಇಂದ ನೀವು ಮಂಗಳ ಗ್ರಹಕ್ಕೆ ಮಾತಾಡಬಹುದು ಅಂತ ಡೆವಲಪ್ಮೆಂಟ್ ಇದೆ, ಫೆಸಿಲಿಟಿ ಇದೆ. ₹25 ಪ್ರೋಸೆಸ್ ಕಟ್ಟಲಿಕ್ಕೆ 5 ವರ್ಷ 8 ವರ್ಷ ಬೇಕು. ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರ ಮೇಲೆ ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು ಕಾಪಿ ಅದರ್ ಸೈಡ್ ಸರ್ವ್ ಮಾಡಿ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡಬಹುದೋ ಬೇಡವೋ ಅಂತ ಹೇಳಲಿಕ್ಕೂ 2 ವಾರ ಟೈಮ್ ಬೇಕು. ಜನಗಳು ನೋಡಿದ್ರೆ ಕೋರ್ಟ್ಗಳನ್ನ ಬಾಯಿಗೆ ಬಂದಂಗೆ ಮಾತಾಡ್ತಾರೆ, ಉಗಿತಾರೆ. ಅಜ್ಜನ ಕಾಲದಲ್ಲಿ ಹಾಕಿರೋ ಕೇಸು ಮೊಮ್ಮಕ್ಕಳು ಬಂದ್ರು ಇನ್ನೂ ಏನು ಮುಂದುವರಿಯಲ್ಲ. ಯಾರದು ಹೊಣೆಗಾರಿಕೆ? ನನ್ನದು ನಿಮ್ಮದು ಇಬ್ಬರದ್ದು. ಮತ್ತೆ 2 ವಾರ ಕೇಳ್ತಿದ್ದೀರಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪರ್ಸನಲ್ ಇನ್ಕಮ್
ನಾಳೆ ಕೇಳಿ ಕೊಡವಲ್ಲ, 2 ವಾರ ಸಾಧ್ಯ ಇಲ್ಲ. ನೀವು ನಾನು ಸಿಟ್ಟಿಂಗ್ ಮಾಡಿಸ್ಬೇಕು 28, 29 ನಾನ್ ಬರಬಲ್ಲೆ ಧಾರಾಳವಾಗಿ.
27 or 30.
There are counsel from both sides present. Counsel for the revision petitioner submits that objections to IA 1/2022 are ready and that is going to file the same in the registry today. List the matter on 27/5.
30th,
35, 2022 as prayed. It is made clear that in case the objections are not placed before this court before said date and the petitioner fail to proceed further in the matter, the court may proceed to pass appropriate order after hearing the party present on IA 1/2022. None appear in this matter, hence the matter could not be proceeded today. Yes. ಮತ್ತೆ 26 ಮ್ಯಾಟರ್ ಇದ್ದಾಗೂ ಯಾಕೆ ಇದು ಹೋದ್ರಿ? It's not the way, not the fair way. ಅವ್ರು ಕೂಗ್ಸಿದ್ರೆ 25 ಮಾತ್ರ ಕೂಗ್ಸಿದಲ್ವೇ ಅವರು? ಅಥವಾ ನೀವಾದ್ರೂ ಹೇಳಿದ್ರ 25, 26 ಕನೆಕ್ಟೆಡ್ ಸ್ವಾಮಿ ಎರಡರಲ್ಲೂ ಒಂದೇ ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ? ಬಹಳ ಹಗುರವಾಗಿ ತಗೊಳ್ತೀರಿ ನ್ಯಾಯಾಲಯದ ಪ್ರೊಸೀಡಿಂಗ್ ಗಳನ್ನ, ಬಹಳ ಹಗುರವಾಗಿ ತಗೊಳ್ತೀರಿ. ಸೇವ್ ಮಾಡಿ.
28,
ಕಾಪಿ ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅದರ್ ಸೈಡ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಯ್ಯ ಕಾಪಿ counsel for the petitioner not present to grant. Counsel for the respondent alone is physically present in the court. In spite of granting sufficient time, the petitioner has not filed his objections to IA 1/21. As final opportunity, a day's accommodation is granted to the petitioner to file his objection, if any, on IA 1/2021 and proceed further in the matter. List this matter on 27/5.
Please, Your Lordship. My lord, because of family wedding, senior was not in town yesterday and today he is back tomorrow.
Yesterday matter was called.
Yes.
Passed over. You adopted a beautiful trick. When the case is called secondary, if you don't go, the matter would stand urgent sine die after some longer time. You forget that I am heading this roster this time. Therefore, for your unfortunate matter has come today from yesterday. Kindly proceed further in the.
My lord, I am making a submission that my colleague was there. I understand that.
Whosoever may be.
Yes.
From your
but I'm telling my lord, this is the real situation. So he is back tomorrow.
No, at least when the matter is passed over, was it not incumbent upon the learned counsel to present when the matter is called again and make a submission,
My
even
apologies.
for seeking an adjournment also?
My apologies, my lord, if that happened.
That too, big officers, they do it.
My apologies.
What impression it creates?
I am not aware under what circumstances this happened. But my
No,
apologies.
these are all buffering submissions. It is a shame. Say the attitude of Chanta hai. Maybe probably by your colleague.
My apologies, my lord. I'm responsible.
Okay, no problem. No, proceed today.
My lord, this is the real thing. And therefore, any time that this court might fix any date next week, we'll complete our side. In fact, a connected matter, CRLP 7026, a copy of the same was served yesterday. So both will review and make submissions, my lord.
2015 crime. 7 years over. Still in the stage of 227 CRPC.
We'll
Can
assess.
you imagine the fate? What could be the fate of the trial, even if it is proceeded? ನಿನ್ನೆ ಬೆಳಗ್ಗೆ ಏನ್ ಬ್ರೇಕ್ಫಾಸ್ಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ನಿಮಗೆ ಇವತ್ತು ನೆನಪಿರಲ್ಲ. ಅಂತದ್ದು 2015 ನಲ್ಲಿ ಏನಾಗಿದೆ ಅನ್ನೋದು 2022 ನಲ್ಲಿ ವಿಟ್ನೆಸ್ಗಳು ಬಂದು ಯೂನಿಫಾರ್ಮ್ ಆಗಿ ಹೇಳಲಿಕ್ಕೆ ಸಾಧ್ಯವೇ? ಬಹಳ ಕಷ್ಟ. ಟ್ರಯಲ್ ರೀಚ್ ಆಗ್ಬೇಕಾದ್ರೆ ಇನ್ನೂ ಲಾಂಗ್ ವೇ ಟು ಗೋ. ಇಲ್ಲೇ ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ರೆ ವೆಲ್ ಅಂಡ್ ಗುಡ್. ಅಂತದ್ರಲ್ಲಿಯೂ ಇಷ್ಟು ಡಿಲೇ ಯಾಕೆ ಹೋಗಿ?
My lord, any day. We'll assess the court any day next week.
Probably sixth time I am sitting in this roster. Every time I sit here in this revision petition roster, I have to beg, borrow, threaten, direct, everything I have to exercise only to see that matter proceeds further, ball moves.
Yes.
There are counsel from both sides physically present. There are counsel for the petitioner. Interesting aspect is that in several of the matter, who should oppose the adjournment? They never oppose. Do not know the reason why, whether it is government or individual advocates. They never open their mouth. That is the greatest contributory factor for the delay. If they oppose, at least the court would be hesitant in granting a long adjournment. They keep quiet and ultimately learned counsel from both sides tell the party, no, the court has adjourned the matter. The litigants roll in the Twitter, Facebook, WhatsApp, etc. My cases of the year 2002, still the matter is being adjourned, being adjourned, being adjourned. What impression it creates? There are counsel from both sides physically present. There are counsel for the petitioner citing some personal inconvenience and undertaking that on the next date of hearing without seeking any further adjournment, he would proceed further in the matters, prays for a short accommodation. It's the matter on 3/6 would be 3/6/2022. On that day, come prepared for the final argument in the matter. And necessary papers, if any, learn HCGP to collect and secure. You also the complainant. We possessed with you the certified copies. So after commencing the argument, neither of you hopefully are not submitting to the court that particular papers are not available either before the court or with you. Yes.
Naughty, SPP.
Yes,
Yes, proceed with the matter, please.
Brought time for the respondent.
Yes.
The entire set of petitions was not served. Only discharge order, not entire records I had.
What not served?
The petition copy.
Petition copy not served.
Charge sheet materials.
They have not filed charge sheet material in the court.
I'll secure it. I don't have entire charge sheet.
You should have secured it by this time.
Last date.
I grant you time, 500 rupees per day. How many days you want? I grant you time. I am not refusing or denying granting time to you. But it costs. Tell me how many days you want. Accordingly, so I will grant you time.
Two days. 2 days.
There are counsel from both sides present. There are counsel for responding. Pays for 2 days accommodation, stating that he would secure the entire charge sheet materials and proceed further in the matter. He undertakes that for any reasons he would not seek any further adjournment. Accordingly, the time as prayed is granted. Use this matter on 2/6/2022.
K. Lakshmikant.
Petitioner.
Yes, please.
The petitioner has challenged the judgment and order of conviction the first appellate court.
Yes.
That for the offense under section 279 304A of IPC.
Yes.
In the incident case, my lord, the prosecution has examined as many as 6 witnesses, 7 witnesses. Out of that, my lord, PW 1 and 2 are witnesses, that eyewitness to the alleged incident. And PW 3 and 4 are the major witness. My lord, PW 5, 6 is the my lord, who is the IO, and 7 is the one of the owner of the transport department. Lord,
Yes, please.
My lord,
You do not dispute the occurrence of accident, right? You do not dispute the involvement of two vehicles, a motorcycle and your lorry. You do not dispute the death of Jagat in the accident due to the injuries sustained by him. Yeah. So the accident is not in dispute. Accident is admitted. Involvement of a motorcycle and the lorry is an admitted fact. The accident was not due to any mechanical defect in the vehicle is also not in dispute. It's only the disputable question. The ground raised by you is regarding the alleged rash and negligent driving of the lorry by the driver. Yes, proceed.
I'm not the driver at the time of the accident.
That is your first difference.
My lord, the evidence of PWA1, who is a friend of the deceased. ಈ ದಿನಾಂಕ 4/6/2014 ಬಾಳೆಗದ್ದೆ ಇಂಟರ್ವ್ಯೂಸ್ ಡೆಕೋರೇಷನ್ ಕೆಲಸ ಮುಗಿಸಿ ಸಕಲೇಶ್ಪುರಕ್ಕೆ ವಾಪಸ್ ಬರಲು ನಾನು ಮತ್ತು ನನ್ನ ಕಾರಿನಲ್ಲಿ ಬರ್ತೀನಿ. ನನ್ನ ಸ್ನೇಹಿತ ಮೃತ ಜಗತ್ ಕೊಲ್ಟಾರ್ ಅವರು ನನಗೆ ಸೇರಿದ ಬೈಕ್ ನಲ್ಲಿ ನನ್ನ ಕಾರಿನ ಮುಂಭಾಗದಲ್ಲಿ ಹೋಗುತ್ತಿದ್ದರು. ಸಕಲೇಶ್ಪುರದ ನಗರದಲ್ಲಿ SBM ಬ್ಯಾಂಕ್ ನ ಮುಂಭಾಗ BM ರಸ್ತೆ ಮೃತ ಜಗತ್ ಕೊಲ್ಟಾರ್ ಅವರು ರಸ್ತೆಯ ಎಡಭಾಗದ ಒಂದು ಲಾರಿ ಎಡಗಡೆಯಿಂದ ರಾಂಗ್ ಸೈಡ್ ಬಂದು ಮೃತನ ಮೋಟಾರ್ ಸೈಕಲ್ಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಸದರಿ ಲಾರಿ ಬೈಕ್ ಸ್ವಲ್ಪ ದೂರ ತಳ್ಳಿ ಹೋಗಿ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿ ನಿಲ್ಲಿಸಿದನು. ಅದರಿಂದ ನನ್ನ ಸ್ನೇಹಿತ ರಸ್ತೆಯ ಪಕ್ಕಕ್ಕೆ ಬಿದ್ದು ಸ್ಥಳದಲ್ಲಿ ಮೃತಪಟ್ಟನು. ಆಗ ಸಮಯ ರಾತ್ರಿ 10:30 ಗಂಟೆ ಆಗಿತ್ತು. ಆಗ ಈ ಅಪಘಾತವು ಲಾರಿಯ ಅಪಘಾತ ಲಾರಿಯ ಚಾಲಕನು ಸ್ಥಳದಲ್ಲಿ ನೋಡಿದನು. ಸದರಿ ಲಾರಿಯ ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಮತ್ತು ನಿಧಾನ ಹೋಗುತ್ತಿದ್ದೆ. ಲಾರಿಯ ತುಂಬಾ ವೇಗವಾಗಿ ಬರುತ್ತಿದೆ. ನಂತರ ಮೃತ ಕೊಲ್ಟಾರ್ ಅವರು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಸಾಗಿಸಿರ್ತಾರೆ. ಆ ಸ್ಥಳದಲ್ಲಿ ವಿದ್ಯುತ್ ಬೆಳಕು ಇದ್ದರಿಂದ ಲಾರಿಯ ಚಾಲಕನನ್ನು ನಾನು ನೋಡಿ ಗುರುತಿಸಿದೆ. This version is first time he has deposed before this court, either in the complaint or in the major matter. It is also not reflected, and the sketch is also produced mirror, wherein also the existence of street light. ನಾನು ನಿಶಾನೆ P1 ಸಾಕ್ಷಿ ಸೋನ್ಸೋ ಮಾದರ್ಗೆ ಸಹಿ ಹಾಕಿದೆನು. ಸಾಕ್ಷಿಯ ಮಾಧ್ಯಮ ಸಹಿ ಸೋನ್ಸೋ ನನ್ನ ಬೈಕ್ ಮತ್ತು ಸದರಿ ಲಾರಿ ಸ್ಥಳದಲ್ಲಿರುವ ಅವುಗಳನ್ನು ಪೊಲೀಸರ ಮಾತುಗಳು ಸದರಿ ಲಾರಿ ಮತ್ತು ಬೈಕ್ ನೋಡಿದ್ರೆ ಗುರುತಿಸಿದ್ದೇನೆ. ಸಾಕ್ಷಿ ಮತ್ತು ಲಾರಿ ಫೋಟೋಗಳನ್ನು ಗುರುತಿಸಿದ್ದು ಸೋನ್ಸೋ ಜಗತ್ ಕೊಲ್ಟಾರ್ ಸಂಬಂಧಿಕನಾಗಬೇಕು. ಈ ಅಪಘಾತದಲ್ಲಿ ನನ್ನ ಕಾರಿಗೆ ಸದರಿ ಲಾರಿ ಡಿಕ್ಕಿ ಹೊಡೆದಿರುವುದಿಲ್ಲ. ಅಪಘಾತ ಸ್ಥಳದಿಂದ ಸ್ವಲ್ಪ ಮುಂದೆ ರಸ್ತೆ ತಿರುವು ಕೂಡಿದೆ. ಸದರಿ ರಸ್ತೆಯಲ್ಲಿ ಸಾಮಾನ್ಯವಾಗಿ ಎಲ್ಲಾ ವಾಹನಗಳು ನಿಧಾನವಾಗಿ ಬರುತ್ತೆ ಎಂದರೆ ಸುಳ್ಳು. ಲಾರಿ ಅಪಘಾತ ಸ್ಥಳದಿಂದ 100 ಅಡಿ ದೂರದಲ್ಲಿ ನಿಲ್ಲಿಸಿ ಆರೋಪಿ ಓಡಿ ಹೋದನು. ಆರೋಪಿ ಓಡಿ ಹೋಗುವಾಗ ನಾನು ಪ್ರಯತ್ನ ಪಡಲಿಲ್ಲ. ನಾನು ದೂರು ಕೊಟ್ಟಾಗ ಮಧ್ಯರಾತ್ರಿ 1 ಗಂಟೆ ಆಗಿರಬಹುದು. ದೂರಿನಲ್ಲಿ ಆರೋಪಿ ಎಷ್ಟು ವಿಳಾಸ ನಮೂದಿಸಿಲ್ಲ. ಲಾರಿ ಮುಂಭಾಗ ಬೈಕ್ಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದಿದೆ. ಲಾರಿ ಮುಂಭಾಗ ನಂಬರ್ ಪ್ಲೇಟ್ ಬೆಂಡಾಯಿತು. ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ದೂರು ಕೊಟ್ಟೆನು. ಮಹಾಜರ್ ಸಮಯದಲ್ಲಿ ನಾವು 3 ಜನ ಬಿಟ್ಟರೆ ಬೇರೆ ಯಾರು ಇರಲಿಲ್ಲ. ಮಹಾಜರ್ ಸಲ ಚೆಕ್ ಬಂದಿ ಗೊತ್ತು ವೃತ್ತ ನಿರೀಕ್ಷಕರು ಬಂದ ಲಾರಿಯಲ್ಲಿ ಪೊಲೀಸರು ಯಾವಾಗ ಅಮಾನತು ಪಡಿತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸದರಿ ಲಾರಿ ಕೆಂಪು ಬಣ್ಣದಿದ್ದು ಈಚೆ ವಾಹನ ಸದರಿ ಲಾರಿ ಕೋಕಾ ಲೋಡ್ ಇತ್ತು. ಅಪಘಾತ ಸ್ಥಳದಲ್ಲಿ ರಸ್ತೆಯಲ್ಲಿ ಯಾವಾಗಲೂ ಜನ ಇರುತ್ತಾರೆ ಎಂದು ಸುಳ್ಳು. ಬೈಕ್ ಲಾರಿಯಿಂದ 12 ಅಡಿ ದೂರದಲ್ಲಿ ಬಿದ್ದು ನಾನು ಮಹಾಜರಿಗೆ ಪೊಲೀಸ್ ಠಾಣೆ ಸಹಿ ಮಾಡಿದೆ ಸುಳ್ಳು. ಈ ಲಾರಿ ಚಾಲಕ ತಪ್ಪಿನಿಂದ ಆಗಿರುವುದು ಸುಳ್ಳು. ಮೃತನ ವಾರಸುದಾರ ಪರಿಹಾರ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದರೆಂದು ನಿಜ. ಸದರಿ ಪರಿಹಾರದ ಕೇಸಿಗೆ ಅನುಕೂಲವಾಗಲಿ ಎಂದು ನಾನು ಪೊಲೀಸರ ಜೊತೆ ಶರೀಕಾಗಿ ಸುಳ್ಳು ದೂರನ್ನು ಕೊಟ್ಟು ಸುಳ್ಳು ಸಾಕ್ಷಿ ನುಡಿಯುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಲಾರಿ ರೋಡಿಗೆ ಬಿಳಿ ಬಣ್ಣದ ಟಾರ್ಪಲಿಂದ ಕಟ್ಟಿದರು. ಮೃತ ತಪ್ಪಿನಿಂದಲೇ ಅಪಘಾತವಿದೆ ಎಂದರೆ ಸುಳ್ಳು. ಆರೋಪಿಯನ್ನು ನಾನು ಈ ದಿನ ಮುಂದೆ ಬಿಟ್ಟರೆ ಬೇರೆ ಎಲ್ಲೂ ನೋಡಿರುವುದಿಲ್ಲವೆಂದರೆ ಸುಳ್ಳು. In the incident case, no test identification paradigm was done and no TI paradigm was done to identify the present petitioner of the driver.
Whether tape is mandatory?
To identify, because he doesn't know the accused here in the incident case. So that that the person who was driving the vehicle he has to identify in the police station or else. And nowhere he is identified. And first of all, he is saying before the court because the
Have you suggested to PW1 in his cross-examination that accused was not driving the lorry at the time of incident? PW1 at more than one places has stated that it was the accused and accused alone who was driving the vehicle, and he has seen the accused in the light available there. Have you anywhere suggested, at least made a denial suggestion to the PW1 that accused was not the driver?
Only last suggestion that
not at the fault of the accused does not mean accused was not the driver.
ಈ ದಿನ ಆರೋಪಿಯನ್ನು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಬಿಟ್ಟರೆ ಬೇರೆ ಎಲ್ಲೂ ನೋಡಿರುವುದಿಲ್ಲ. This was suggestion was. And my lord, he is saying that there was a street light, but the street light spot catch is also there, and spot margin is also there. My lord, in the spot sketch, my lord, they have shown the double electric pole, man. And the existence of street light is not forthcoming in the margin.
Where PW1 has stated that there was a street light. Read that sentence, please.
ಆ ಸ್ಥಳದಲ್ಲಿ ವಿದ್ಯುತ್ ಬೆಳಕು ಇದ್ದರಿಂದ ಲಾರಿಯ ಚಾಲಕವನ್ನು ನಾನು
ವಿದ್ಯುತ್ ಬೆಳಕು, does it mean necessarily only the street light?
Because it is a highway, my lord.
No, don't presume things.
As per his sketch, my lord.
Don't presume things. Did you elicit what was the electricity light that was available there? You have not elicited. Have you suggested anything regarding the non-availability of any street light there? You haven't. Then what are the things you are required to do in the cross-examination? You haven't done. Can you fill those lacunas in the revision? Basically, this court need not reappreciate the entire evidence in the revision. Scope is very much limited. But despite me 1,000 times telling, every advocate commences their argument as though it is a first appeal, and compel this court to reappreciate the entire evidence in all cases and all circumstances. Neither PW1 nor PW2 have stated that there was a street light. They have spoken about the availability of electricity there. The same has not been denied. Yes.
PW1 is Malad is the relative.
Yes.
Who may say that the PW2 man, who is the independent witness. In his cross-examination, he has admitted that he cannot say that the color of the vehicle. One of the point which is required. ಲಾರಿಯ ಬಣ್ಣ ಮತ್ತು ಅದು ಯಾರ ಮಾಲೀಕತೆ ಸೇರಿದೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Which create that may not that the presence of the PW2 spot. And further ನಾನು ಯಾವ ಪೊಲೀಸ್ ಅಧಿಕಾರಿಗೆ ನೀಡಿದ್ದೇನೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ಅದು ಎಷ್ಟು ಗಂಟೆ ಕೊಟ್ಟರು ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಈ ಅಪಘಾತವನ್ನು ನೋಡಿಲ್ಲ ಅಂದ್ರೆ ಸುಳ್ಳು. ಈ ಆರೋಪಿಗೂ ಅಪಘಾತಕ್ಕೆ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಅಂದ್ರೆ ಸುಳ್ಳು. ಆರೋಪಿ ಈ ದಿನ ನ್ಯಾಯಾಲಯ ಬಿಟ್ಟರೆ ಬೇರೆ ಎಲ್ಲೂ ನೋಡಿಲ್ಲ.
Yes.
PW3 is also my lord. He is a friend of the PW1.
He is only a punch of or scene of offense.
Is that
Any other points? Exhibits, could you? Yes. SGP.
In this case, the PW1 to the eyewitness incident. The accident has taken place on 4/6/2004 at 10:30 p.m. near the SBM Bank, Sakleshpura town. It is inside the city, my lord. The accident has taken place, my lord. And the PW1 and 2 were coming in the car just behind the bike of the deceased man. They have clearly seen the accident, my lord, and they have narrated the nature of accident in their deposition, in their evidence also. They have identified the accused also. And the PW7, who is the owner of the lorry, he has also stated that the accused was the driver of the lorry on the said date.
Since about 1 year continuously, he was the driver, right?
He was and the accused does not explain anything about the accident, not how the accident happened
In 313 statement.
also. As the eyewitnesses have supported the case of prosecution and they have clearly stated that the bike was dragged nearly 200 to 150 feet and the wheels were passed over the deceased person. The prosecution has clearly proved the case. Hence, the order passed by the trial court as well as the appellate court is proper, there is no illegality or perversity in the judgment. The 1 and 2 also have clearly stated about the negligence of the driver of the lorry.
Please be seated. Section 279, confirmation of conviction. Section 279, 304 IPC. Formatted in election room in the detection certificate. Similar matters. The case of the prosecution is that the date 4/6/2014 at about 10:30 p.m. in Sakleshpura town on NH48 BM Road near State Bank of Mysuru. To the deceased, Jagat Kolchar was going on his motorcycle wearing registration number KA21L2914 from Sakleshpura town towards on the left side of the road, the accused being a driver of a motor vehicle lorry bearing registration number KA53B4300 drove the same in a rash and negligent manner with high speed and coming from opposite side dashed against the motorcycle of the deceased, due to which road traffic accident the deceased sustained severe injuries and died on the spot. Thus, the accused has committed offence punishable under section 279 304A of Indian Penal Code. ಗಾಡಿ ನಂಬರ್ ಮೋಟರ್ ಸೈಕಲ್ ನಂಬರ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ನಂಬರ್ ಇದನ್ನು ಹಾಕಿ ಉಳಿದಿರೋದೆಲ್ಲ ಫಾರಿನ್ ಪ್ರಕಾರ ಬರಲಿ. Points for consideration ಇದೆ ಅದನ್ನೇ ಸ್ಟ್ರೈಕ್ ಮಾಡಿ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಹಾಕಿ. Learned counsel for the petitioner in his brief argument submitted that would not dispute the occurrence of the road traffic accident on the date, time, and place mentioned in the charge sheet. Would also not dispute fact of death of this is Jagat Kolcha. He said road traffic accident who was the rider of a motorcycle bearing registration number KA21L2914. Would also not dispute that the said death of Kolchar was due to injuries sustained by him in the said road traffic accident. However, he would strongly dispute and deny that it was the petitioner himself who was the driver of the offending lorry bearing registration number KA53B4300 at the time of accident. He further submitted that even though PW1 and 2 are projected as eyewitnesses to the incident, but their evidence regarding the identity of the accused. A space ಬಿಡ್ತಾ ಇದ್ದೀರಿ ಆಮೇಲೆ ನಿಮಗೆ ಬೇಕಾಗಿರೋದನ್ನ ಬರ್ಕೊಳ್ತೀವಿ.
ಇಲ್ಲ ಸರ್, ಐವಿಟ್ನೆಸ್ ಅಂತ ಬರ್ಕೊಳ್ತೀವಿ.
Their evidence regarding the identity of the accused would not inspire any confidence to believe in them. Admittedly, no test identification parade has been conducted in the matter. He further submits that PW2, though is an independent witness, however, his presence at the time of accident is not, his presence in the spot at the time of accident is doubtful since he was unable to mention the color of the offending vehicle, that is the lorry. Thus, the impugned judgment deserves interference at the hands of this court. For contra, or in HCGP appearing for the respondent in her brief argument submits that PW1 and 2 are the eyewitnesses to the incident who have given a uniform detail about the occurrence of the accident. Their evidence inspires confidence to believe. Both the witnesses have seen and identified the accused both at the spot of the accident as well in the court of law. Since the incident has occurred in the city limits and the witnesses have spoken about the availability of electricity light in the spot at the time of accident, they have identified the accused clearly. She further contends that PW7, who is none else than the representative of the owner of the offending vehicle himself, has stated that it was the accuser and accused himself who was driving the lorry belonging to them, at the time of accident. Thus, the identity of the accused, as well the fact that he was driving the vehicle at the time of accident, has been established beyond doubt. The evidence of the eyewitnesses and the medical opinion, as shown in the postmortem report, would clearly go to show that death of Jagat was due to the injuries sustained by him in the road traffic accident. As such, the rash and negligent driving of the accused causing death of deceased Jagat Kolchar has stood proved beyond reasonable doubt. PW1 and PW2 have claimed themselves to be the eyewitnesses to the incident. Both of them have uniformly stated that the date of incident, which was on 4/6/2014, in the night at about 10:30 p.m., they were going on the same road on which the deceased Jagat was going on his motorcycle. However, the said motorcycle was ahead of the motor cars in which these two witnesses were traveling. Both these witnesses have also stated that why their vehicle as well as that of the motorcycle of the deceased, which was being ridden by the deceased, were going on BM Road in the town of Sakaleshapura, then in front of State Bank of Mysore. A lorry being driven by its driver in a rash and negligent manner came from the wrong side and dashed to the motorcycle, and it dragged the motorcycle for some distance and came to a halt. Due to the said road traffic accident, the rider of the motorcycle sustained injuries and succumbed to it on the spot. Both the witnesses have further stated that they have seen the accused in the spot as the driver of the said lorry in the electricity light which was available in the spot. Sapyara. PW1 further has stated that the deceased was his friend. As such, after witnessing the accident and identifying and seeing the accused, he lodged a police complaint on the same night, which complaint he has identified at Exhibit P1. It has also stated that on the next day, the police visited the spot as shown by him and drew a scene of offense Panchanama in his presence as per Exhibit P2. The witness has also stated that the motorcycle which was damaged, as well the lorry which was stopped near the spot of the accident, were seized by the police under the Panchanama. The photographs of those vehicles he has identified at Exhibit P3 and P4 respectively. Both PW1 and PW2, apart from stating that they have seen the accused in the spot of the accident as the driver of the vehicle, have also identified him in the court of law. Both PW1 and PW2 were subjected to a detailed cross-examination from the accused side wherein also denying the suggestions made to them, the witnesses have adhered to their original version that they were the eyewitnesses to the accident and it was the accuser and accused alone or whose rash and negligent driving the accident in question has occurred. Both of them have further stated that after making the lorry to come to a halt at a distance of few feet away from the place of accident, the accused got down from the lorry and ran away from the place. Thus, in their cross-examination, they have given more details about the accident and have further strengthened their evidence that was given in their examination in chief. However, no attempt was made from the accused side in denying either the identity of the accused or there is a fact that the accused was the driver of the offending lorry at the time of the accident. They are added to the above. PW7, K. Raju Kumar, who claims himself to be the manager of Messrs. Sriram Transport Company, to which company the offending vehicle belongs to, has also stated that after receiving a police notice as per Exhibit P7, he had visited the police station and came to know about the accident. He has specifically stated that it was the accused who was present before the court, was appointed as the driver of the lorry since about a year prior to the accident. And since then, it was the accused and accused alone who was driving the said lorry. The witness, apart from stating that he had got the release of the said offending vehicle in favor of their company at their interim custody, has also identified the said lorry through photograph at Exhibit P3. They have identified the accused in the court. The above evidence of PW1, PW2, and more particularly, the evidence of PW7, who is none else than the employer of the accused, establishes beyond any doubt that it was the accused and accused alone who was the driver of the offending vehicle at the time of the incident. Therefore, the argument of the learned counsel for the petitioner that the petitioner was not the driver of the offending vehicle at the time of the accident is not acceptable. Correct. Both PW1 and PW2, apart from giving a detailed description of the incident, have also given the details about the involvement of the lorry bearing registration number K53B4300 as the offending vehicle in the accident. Merely because PW2, who was one of the commuter in a motor vehicle on the said road at the time of accident, come the eyewitness to the incident, could unable to give the specific color of the lorry, that itself would not create any doubt in his evidence that he was an eyewitness to the incident and the description of the occurrence of the accident given by him. When the alleged involvement of the lorry wherein registration number KA53B4300 has not been specifically denied or disputed either in the cross-examination of PW1, PW2, or PW7, merely because PW2 not speaking about the lorry would not take away the fact that it was the offending lorry bearing registration number KA53B4300, which was the vehicle involved in the accident as an offending vehicle. The evidence of PW7 gives more weightage to the evidence of prosecution in establishing that it was the said lorry alone that was involved in the accident as an offending vehicle. Therefore, the argument of the learned counsel for the petitioner that inability of PW2 to describe the color of the offending vehicle would create some doubt in his evidence is also not acceptable. Where PW3 has given a detailed account of the police drawing a scene of offense Panchanama, keeping him as a pancha to the said Panchanama, which he has identified at Exhibit P2. PW4, the investigating officer, has given the details of the investigation conducted by him in the case. PW5, the Assistant RPO of Sakaleshapura has spoken about at the request of the complaint police, visiting the spot and attending to the inspection of the vehicles involved in the accident and inspecting both the vehicles. He has also identified the report, IME report given by him at Exhibit P9, and has opined that according to him, the accident was not due to any mechanical defect of either of the vehicle. Thus, the evidence of the prosecution witnesses, though was attempted to be demolished in their cross-examination, but the defense could not able to succeed in this said attempt. On the other hand, the prosecution witnesses, more particularly PW1, 2, and 7, have not only spoken categorically about the occurrence of accident, but also the involvement of the petitioner as the driver of the offending vehicle at the time of accident. Thus, the oral evidence as well as the documentary evidence clearly go to establish that the road traffic accident as alleged in the charge sheet involving the offending lorry bearing registration number K53B4300 has occurred on the date, time, and place alleged in the charge, and it was the accused who was driving the offending vehicle, and it was at his rash and negligent driving alone the accident which has resulted in the death of deceased Jagat Kolcha has taken place. Thus, both the trial court as well as the first appellate court since have convicted the accused by appreciating the evidence placed before them in their proper perspective. I do not find any reason to interfere in them. Next line. It is the sentencing policy that the sentence ordered for any proven guilt must be proportionate to the gravity of the proven guilt. In the instant case, the trial court has sentenced the accused to undergo simple imprisonment for so for so offense. ಅದೆಲ್ಲದು ಫಾರ್ಮ್ಯಾಟ್ ನಲ್ಲಿ ಮನೆ ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ಹಾಕಿ no reason to interfere ಅಂತ ಮಾಡಿ ಕನ್ಫರ್ಮ್ ಅಂತ ಮಾಡಿ registry to transmit a copy of this.
Sentence is concerned, he is engaged and he is having children.
I have seen the sentence ordered is very minimum. Yes. Next.
Serial number 32, my lord. I am for the respondent, my lord.
32 move ಮಾಡಿ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ನೋಡಿ ಬೆಳಗ್ಗೆ. Yes.
Sorry, my lord. I have not been informed. Any date has been given.
You should have informed who has not done.
They have taken advantage, my lord.
That for in the emergency.
34, Kempegowda, MK Kempegowda.
The counsel for the petitioner called out, but he has remained absent. The respondent, though served, has remained absent. Considering the nature of the revision petition and the nature of the alleged offence, I am of the view that to place the case of the respondent, the complainant, and amicus curiae be appointed. Accordingly, learned counsel Sri S. Javed, who is physically present in the court, is appointed as amicus curiae for the respondent in this matter. Learned amicus curiae Sri S. Javed takes notice for the respondent. Mundinella haki registry to furnish the said learned amicus curiae the entire set of deposition exhibits, etc., etc. Format nalli. Making it clear that in case the learned counsel for the petitioner fails to appear on the next date of hearing and proceed further in the matter, the court may proceed to pass appropriate order. As a final last opportunity, a week's accommodation is granted. Is this matter on 7/6 agbodenri 7th June? Is this matter on 7/6? (138) case we are for complainant. Concurrent finding, yes.
35, Kempegoda, MK, Kempegoda.
Inspection memorandum. Case number 35 nu same order ಮಾಡಿ. Mr. Javed, amicus curiae respondent. Similar case, the same accused. Same date.
36, Manjula Priya, Amit Deshpande, amicus curiae.
Yes, I appear for the respondent. I represent the petitioner.
Yes. Yes. Let's call it.
Amicus curiae, seal number 36.
The original counsel for the petitioner, Shri B.R. Manjuna, is physically present and has filed IA number so and so under 482 section 482 BC seeking the calling of the order dated 5/10/2021 and discharging the amicus curiae and also to permit him to proceed further in this matter. There was the affidavit accompanying the application, heard submission from both sides. Considering the fact that on the dates of hearing, the original counsel for the petitioner had remained as absent, this court by the order dated 5/10/2021 had appointed learned counsel Shri Amit Deshpande as amicus curiae in this matter. Now the previous counsel for the petitioner has come up with the present application seeking permission for him to proceed further in this matter as appearing for the petition. Considering the reasons shown in the affidavit and also of no objection by the learned amicus curiae, comma, the IA number so and so is allowed in part and the learned amicus curiae is permitted to retire from this matter and the original counsel for the petitioner, Shri B.R. Manjunath, is permitted to proceed further in this matter by addressing his argument on main matter without taking any adjournment and also subject to the condition of the original counsel, subject to the condition of the petitioner paying an honorarium of a sum of ₹1,000 to the learned amicus curiae by respecting the labor put by the learned amicus curiae in presenting the matter. This is the amount to be deposited by the petitioner in the registry during the course of the day. This said amount is payable to the amicus curiae Shri Amit Deshpande as such. The amount deposited, if any, by the petitioner be released in favor of the learned amicus curiae Amit Deshpande by the registry without any further order by this court. Yeah. Proceed with the matter.
Present revision petition is filed by the accused. wherein my lord, the respondent had filed a private complaint for the offence punishable under section 138 of Negotiable Instruments Act. But the learned magistrate had convicted the petitioner for the said offence. But the check amount was for a sum of rupees 9,50,000. But the learned magistrate has sentenced, directed the petitioner to pay a sum of rupees 9,75,000 in default to undergo simple imprisonment for 1 year. But against which, my lord, an appeal was filed before the learned session judge. Learned session judge also found that the judgment passed by the learned magistrate was correct, and he did not interfere with the judgment passed by the learned magistrate, and dismissed the appeal filed by the petitioner herein. But against which, my lord, the present petitioner is before your lordship, seeking setting aside of both the judgments passed by the trial court as well as by the appellate court. But it is the case of the respondent that the respondent was working as a director in the Ministry of Labor and Employment for the last 15 years. But the accused, that is the petitioner, was working as a security guard in the very same department. Since they had acquaintance, as both of them were working in the same department, but as both of them had hailed from Karnataka, it is the further the case of the respondent that, my lord, the petitioner was also doing real estate business. He had also let out 2 vehicles for hire. But under that circumstance, my lord, the petitioner had sought financial assistance from the respondent to a tune of rupees 9,50,000. Accordingly, my lord, the respondent had paid the said amount to the petitioner herein. So, while paying the amount, my lord, the petitioner had executed on-demand promissory note, and he had agreed to return the same within a period of 30 days. But after the expiry of 30 days, my lord, the petitioner did not return the said amount. But in order to discharge his debt, my lord, the petitioner had issued the check in question to the respondent. So the respondent had presented the said check for encashment. It was dishonored with Shara funds insufficient. Thereafter, a legal notice was issued by the respondent petitioner, calling upon the petitioner to pay the amount covered under the check. But though the legal notice was served upon the petitioner, petitioner did not choose to pay the amount covered under the check, nor he had failed. He had also failed to reply to the notice issued by the respondent herein. Under that circumstance, my lord, the respondent filed a private complaint under section 200 of CRPC before the learned magistrate. But initially, my lord, there was delay, my lord, in filing the complaint. It was not filed within the stipulated period. An application was filed seeking condonation of the delay. The learned magistrate condoned the delay. So statement of the respondent was recorded. Thereafter, my lord, summons was issued to the petitioner. Upon receiving the summons, my lord, the petitioner appeared before the learned magistrate. But the plea was recorded. He did not plead guilty. But under that circumstance, my lord, the respondent himself got examined as PW1. But the respondent got marked exhibit P1 to P14 documents. But thereafter, my lord, 313 statement of the petitioner was recorded. Thereafter, my lord, the petitioner himself was examined as DW1, got marked the exhibit D1 document. But in spite of cogent defense produced by the petitioner herein before the learned magistrate disbelieved the version of the petitioner and believed the version of the complainant and convicted him for the 138 of Negotiable Instruments Act. But, I am seeking setting aside of both the judgments passed by the courts below on the ground that, my lord, the respondent herein did not had financial capacity of rupees 9,50,000 in order to lend to the petitioner herein. And the other ground is that prior to this transaction, as claimed by the respondent herein, petitioner had availed a sum of rupees 1,70,000 from the respondent herein. He had even repaid the said amount to a check that has been reflected in the account statement of the petitioner and also the account statement of the respondent, which were produced before the learned magistrate. So this check, which is in question now, that was given to the respondent herein when he had availed a sum of rupees 1,70,000. In spite of repayment of rupees 1,70,000, my lord, the respondent had not returned the check and he has misused the said check and he had filed the complaint for the learned magistrate. On these two grounds, my lord, I am seeking acquittal of the petition. In this regard, my lord, if your lordship can come to the cross-examination of PW1.
Yes.
May I read the cross-examination?
Please.
This is dated 25/5/2016, my lord, cross-examination.
Okay.
25/5/2016.
Yes.
ಆರೋಪಿ 994 ಅಥವಾ 995ರಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ನಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಆಗಿ ಕೆಲಸಕ್ಕೆ ಸೇರಿದ್ದು. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಸದರಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ನಲ್ಲಿ ಜಂಟಿ ನಿರ್ದೇಶಕನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು ಆತನ ಪರಿಚಯವಾಗಿರುತ್ತದೆ. ನೀವು ಹೇಳುತ್ತಿರುವಂತೆ ಆರೋಪಿ ಸದರಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿರಲಿಲ್ಲ, ಚೌಕಿದಾರನಾಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು ಎಂದರೆ ಸಾಕ್ಷಿ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಹಾಗೂ ಚೌಕಿದಾರ ಎರಡೂ ಸಹ ಒಂದೇ ಅರ್ಥದ ಹುದ್ದೆಗಳೆಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು ಅಲ್ಲಿಂದ 2002ರಲ್ಲಿ ಕೋಲ್ಕತ್ತಾಗೆ ವರ್ಗಾವಣೆಯಾದೆ. ನಾನು ಕೋಲ್ಕತ್ತಾದಲ್ಲಿ ಅಡ್ವಾನ್ಸ್ ಟ್ರೈನಿಂಗ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ನಲ್ಲಿ ನಿರ್ದೇಶಕ ಹಾಗೂ ಇಲಾಖೆಯ ಮುಖ್ಯಸ್ಥನಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೆ. ಸದರಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ನಾನು ಸದರಿ ಸಂಸ್ಥೆಗೆ ಬೇಕಾದಂತಹ ವಸ್ತುಗಳನ್ನು ಖರೀದಿ ಮಾಡುವ ಅಧಿಕಾರ ಹೊಂದಿದ್ದೇನೆ ಅನ್ನೋದು ಸರಿಯಲ್ಲ. 2005ರಲ್ಲಿ CBI ಇಂದ ನನ್ನ ವಿರುದ್ಧ ಟ್ರ್ಯಾಪ್ ಮಾಡಲಾಯಿತು ಎನ್ನುವುದು ಸರಿ. ನಾನು ಮೆಟೀರಿಯಲ್ಸ್ ಖರೀದಿಸುವಾಗ ನಾನು ಲಂಚ ಪಡೆದುಕೊಳ್ಳುತ್ತಿದ್ದಾಗ CBI ನಿಂದ ನನ್ನ ಮೇಲೆ ಟ್ರ್ಯಾಪ್ ಮಾಡಲಾಯಿತು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆ ನಂತರ ನಾನು ಸೇವೆಯಿಂದ ಸಸ್ಪೆಂಡ್ ಆಗಿ ನನಗೆ ಸಂಬಳ ಬಂದಿಲ್ಲ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ನಾನು ಸಸ್ಪೆಂಡ್ ಆಗಿದ್ದು ನಿಜ, ಆದರೆ ನಾನು ನಿವೃತ್ತಿ ಹೊಂದುವವರೆಗೂ ನನಗೆ 75% ಮೂಲ ಭತ್ಯ, ತುಟಿ ಭತ್ಯ ಹಾಗೂ ಇತರೆ ಭತ್ಯೆಗಳನ್ನು ನೀಡಲಾಗಿದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ CBI ಪೊಲೀಸರು ನಮ್ಮ ಮನೆಯಿಂದ ಕೆಲವು ದಾಖಲೆಗಳನ್ನು ಸೀಸ್ ಮಾಡಿದ್ದರು ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ CBI ಪ್ರಕರಣ ಈಗ ಯಾವ ಹಂತದಲ್ಲಿ ಇದೆ ಅಂದರೆ ಸಾಕ್ಷಿಯು ಅದು ಈಗ ಕೋಲ್ಕತ್ತಾ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಇದ್ದು ಇನ್ನೂ ವಿಚಾರಣೆಗೆ ಬರಬೇಕಾಗಿದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. 2005ರಲ್ಲಿ ನನ್ನ ಮೇಲೆ ಟ್ರ್ಯಾಪ್ ಆದ ನಂತರ ನಾನು ಕೆಲಸಕ್ಕೆ ಹಾಜರಾಗಿಲ್ಲ. ಕೋಲ್ಕತ್ತಾದಲ್ಲಿ CBI ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನನ್ನ ವಿರುದ್ಧ ತೀರ್ಪು ಆಯಿತು. ಅದರ ವಿರುದ್ಧ ಕೋಲ್ಕತ್ತಾ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದೇನೆ. CBI ಕೋರ್ಟಿನಲ್ಲಿ ನಿಮ್ಮ ವಿರುದ್ಧ ಆದ ತೀರ್ಪಿನ ಪ್ರತಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುತ್ತೀರಾ ಎಂದರೆ ಸಾಕ್ಷಿ ಏಕೆ ಹಾಜರುಪಡಿಸುತ್ತಾರೆ ಎನ್ನುತ್ತಾರೆ. 2003ರಲ್ಲಿ ನೀವು GPF ಹಣವನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದೀರಾ ಎಂದು ಹೇಳಿದ್ದು ಯಾವ ಕಾರಣಗಳಿಗಾಗಿ ಸದರಿ ಹಣವನ್ನು ಪಡೆದುಕೊಳ್ಳಬಹುದೆಂದು ಹೇಳುತ್ತೀರಾ ಎಂದರೆ ಸಾಕ್ಷಿಯು ನಾವು ಇಲಾಖೆಯಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುವಾಗ 40 ಕಾರಣಗಳಿಗಾಗಿ GPF ಹಣವನ್ನು ಡ್ರಾ ಮಾಡಬಹುದೆಂದು ಹೇಳುತ್ತಾರೆ. ಯಾರಿಗಾದರೂ ಸಾಲ ಕೊಡಬೇಕೆಂದು GPF ಹಣವನ್ನು ಡ್ರಾ ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲ. This is very important. It is his case that my lord, he had withdrawn the amount which was in his GPF account. He had kept it in the house. That amount he had given as hand loan to the.
Where he has stated that I had withdrawn the GPF amount. And
Lord, examination in chief may kindly be seen. Please.
It is that amount I.
Third page may kindly be seen. Paragraph 12, chief examination. I submit that I retired as the Director, Ministry of Labour, Director General of Employment and Training on 31/5/2009 on superannuation. While in service, I drew GPF amount as follows. He mentions the amounts on the various dates he had withdrawn from his GPF account. As totally As such, totally I had received 11,45,663 as my GPF benefits. Apart from this, I was also drawing monthly pension. As such, I was capable of giving loan of rupees 9,50,000 to the accused on 25/2/2011. This is the chief examination of the PW1. Cross examination ಅಲ್ಲಿ ಯಾರಿಗಾರು ಸಾಲ ಕೊಡ್ಬೇಕಾದ್ರೆ GPF ಹಣ ಕೊಡೋದಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ ಅಂತ ಈ ಅಡ್ಮಿಟ್ಸ್. Whereas ಚೀಫ್ ಅಲ್ಲಿ ನಾನು GPF
ಹಣ ತಗೊಂಡು ಆ GPF ಹಣನ ಸಾಲಕ್ಕೋಸ್ಕರ ನಾನು
ವಿಡ್ರಾ ಮಾಡಕ್ ಆಗಲ್ಲ ಅಂತ
ಸಾಲಕ್ಕೋಸ್ಕರ ವಿಡ್ರಾ ಮಾಡಿ ಆ GPF ಹಣನೇ ನಾನು ಅವರಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ತೋರಿಸಿ.
ಆತರ
ಮತ್ತೆ ಯಾಕೆ ಟ್ವಿಸ್ಟ್ ಮಾಡ್ತೀರಿ? ಅವ್ರು ಹೇಳಿದ್ರೆ ನಾನು ರಿಟೈರ್ ಆಗಿದ್ದೇನೆ, GPF ಇಂದ ಇಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ, GPF ಇಂದ ಇಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ, ಇಂತಿಂತರಿಂದ ಇಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ, ಆಮೇಲೆ ನನಗೆ ಪೆನ್ಷನ್ ಬರುತ್ತೆ, ನಾನು ಜಾಯಿಂಟ್ ಡೈರೆಕ್ಟರ್ ಆಗಿ ಸರ್ವ್ ಮಾಡಿದವನು ಸೆಂಟ್ರಲ್ ಮಿನಿಸ್ಟ್ರಿಯಲ್ಲಿ, ಹಾಗಾಗಿ ನನಗೆ ಫೈನಾನ್ಷಿಯಲ್ ಕೆಪಾಸಿಟಿ ಇತ್ತು ಕೊಡ್ಲಿಕ್ಕೆ ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ. ಅವರ GPF ಹಣನ ಡ್ರಾ ಮಾಡಿ ಮನೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ರು, ಆ ಹಣನೇ ಇವರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ ಇಲ್ಲೇ ಇರೋದನ್ನ ನೀವು ಯಾಕೆ ಸೇರಿಸ್ತೀರಿ? Advocate shouldn't do that. Yes.
Further proceed with the further class examination. ನಾನು 2003ರಿಂದ 2009ರವರೆಗೆ ಸುಮಾರು 6 ಲಕ್ಷ ಹಾಗೂ ಅದರ ಮೇಲ್ಪಟ್ಟ ಹಣವನ್ನು GPF ನಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ. ನೀವು ಸಸ್ಪೆಂಡ್ ಆದ ನಂತರ ನಿಮಗೆ ಭತ್ಯೆಗಳನ್ನು ನೀಡಲಾಗಿತ್ತು ಎಂದು ಹೇಳಿದ್ದು, ಅದನ್ನು ಯಾವ ರೀತಿ ಪಡೆದುಕೊಂಡಿದ್ದೀರಿ ಎಂದರೆ ಸಾಕ್ಷಿ DD ಮೂಲಕ ಪಡೆದುಕೊಂಡಿದ್ದೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಆ ರೀತಿ DD ಮೂಲಕ ಸದರಿ ಭತ್ಯೆಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು, ಸದರಿ DDಗಳು ಕ್ಯಾಶ್ ಆಗಿದೆ ಎನ್ನುವ ಸಂಬಂಧ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಬಹುದೇ? ಅಂದರೆ ಸಾಕ್ಷಿಯು ನ್ಯಾಯಾಲಯ ನಿರ್ದೇಶಿಸಿದರೆ ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ಸ್ ಅನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆಂದು ನುಡಿಯುತ್ತಾರೆ. ನನಗೆ GPF, ಗ್ರೂಪ್ ಇನ್ಶೂರೆನ್ಸ್, ರಜೆ ನಗದೀಕರಣ, ಪಿಂಚಣಿ ಬಾಕಿ ಹಣ ಒಟ್ಟು ಎಲ್ಲಾ ಸೇರಿ 11,45,663 ರೂಗಳು ಬಂದಿರುತ್ತದೆ. ನನಗೆ 2 ಹೆಣ್ಣು ಮಕ್ಕಳು, ಒಬ್ಬ ಮಗ. ನನ್ನ ದೊಡ್ಡ ಮಗಳಿಗೆ ಮದುವೆಯಾಗಿ ವಿಚ್ಛೇದನವಾಗಿರುತ್ತದೆ. 2002ರಲ್ಲಿ ನನ್ನ ಹಿರಿಯ ಮಗಳಿಗೆ ಮತ್ತು ನನ್ನ ಕಿರಿಯ ಮಗಳಿಗೆ 2008ರಲ್ಲಿ ಮದುವೆಯಾಗಿರುತ್ತದೆ. 2008ರಲ್ಲಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ ನನ್ನ ಕಿರಿಯ ಮಗಳ ಮದುವೆ ಮಾಡಿರುತ್ತೇನೆ. ಸದರಿ ಮದುವೆಗೆ ನಾನು ಸುಮಾರು 6 ಲಕ್ಷ ರೂಗಳನ್ನು ಖರ್ಚು ಮಾಡಿರುತ್ತೇನೆ. CBI ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನನ್ನ ವಿರುದ್ಧ ತೀರ್ಪು ಆದ ಕಾರಣಕ್ಕಾಗಿ ನಾನು ಹೇಳುತ್ತಿರುವಂತೆ ನನಗೆ ಯಾವುದೇ ಭತ್ಯೆಗಳನ್ನು ಬಂದಿಲ್ಲ ಅನ್ನುವುದು, ಆದರೂ ಸಹ ಆ ರೀತಿ ಭತ್ಯೆಗಳು ಬಂದಿದೆ ಎಂದು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P8 ಮತ್ತು 9ರ ಪ್ರಕಾರ ನನ್ನ GPF ಸಂಬಂಧ ಆದೇಶ ಆಗದಿದ್ದರೂ ಸಹ ಸದರಿ ಹಣವನ್ನು ನನಗೆ ನೀಡಲಾಗಿಲ್ಲ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆ ಸಂಬಂಧ ನನ್ನ ಇಲಾಖೆಯಿಂದ ಮಾಡಲಾದ ಆದೇಶವನ್ನು ನ್ಯಾಯಾಲಯ ಸೂಚಿಸಿದ ಪಕ್ಷದಲ್ಲಿ ಹಾಜರುಪಡಿಸುತ್ತೇನೆ. ನಾನು ಯಾವ ದಿನಾಂಕಗಳನ್ನು ಬ್ಯಾಂಕ್ನಿಂದ ಹಣ ಡ್ರಾ ಮಾಡಿ ತಂದು ಮನೆಯಲ್ಲಿ ಇಟ್ಟಿದ್ದೆ ಎಂದು ಸಾಬೀತುಪಡಿಸುವ ಸಂಬಂಧ ನಿಶಾನೆ P12 ಮತ್ತು 13 ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. These are the bank statements of the petitioner. ನಿಶಾನೆ P12ರ ಪ್ರಕಾರ ದಿನಾಂಕ 31/3/2010 ಅವಧಿಗೆ ನನ್ನ ಖಾತೆಯಲ್ಲಿ 19,464.56 ರೂಗಳು ಇರುತ್ತದೆ. ಸಾಕ್ಷಿಯು ಸ್ವತಃ ಮುಂದುವರೆದು ಸದರಿ ಮೊತ್ತ ನನ್ನ ಖಾತೆಗೆ ಸದರಿ ವರ್ಷದಲ್ಲಿ ನಾನು ನನ್ನ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಿದ ಮೊತ್ತವಾಗಿದ್ದು, ನನ್ನ ಖಾತೆಯಲ್ಲಿ ಇದ್ದ ಒಟ್ಟು ಬ್ಯಾಲೆನ್ಸ್ ಅಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. That was the only balance which was available in his account as on that day. ದಿನಾಂಕ 1/8/2010ರಂದು ನಿಶಾನೆ P14ರ ಪ್ರಕಾರ ನನ್ನ ಖಾತೆಯಲ್ಲಿ 5,709 ರೂಗಳು ಮಾತ್ರ ಇತ್ತು. ನಿಶಾನೆ P13ರ 4ನೇ ಪುಟದಲ್ಲಿ 28/12/2010 ಎಂಟ್ರಿ ಪ್ರಕಾರ ನಾನು ಜಯಪ್ರಕಾಶ್ ಅಸೋಸಿಯೇಟ್ಸ್ ಲಿಮಿಟೆಡ್ ನಲ್ಲಿ 3 ಲಕ್ಷ ರೂಗಳನ್ನು ಹೂಡಿಕೆ ಮಾಡಿದ್ದೇನೆ ಎಂದು ಕಾಣಿಸಲಾಗಿದೆ ಅನ್ನುವುದು ನಿಜ. ಸದರಿ ಎಂಟ್ರಿಯನ್ನು ನಿಶಾನೆ P13A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. His claim is that he had withdrawn the amount from GPF that was paid through DDs. Those DDs were presented to his account and he had the sufficient money in his account. But here is a case where he had invested 3 lakhs with Jaiprakash Associates.
Totally 12 lakh he has invested.
Please. ಅದೇ ಪ್ರಕಾರ ನಿಶಾನೆ P14ರ 3ನೇ ಪುಟದಲ್ಲಿ
28/12/2010 ಎಂಟ್ರಿ ಪ್ರಕಾರ ನಾನು ಜಯಪ್ರಕಾಶ್ 3 ಲಕ್ಷ ಹೂಡಿಕೆ ಮಾಡಿದ್ದೇನೆ ಅನ್ನೋದು ನಿಜ.
ಮುಂದಕ್ಕಿದೆ ಮತ್ತೆ
ಮುಂದೆ ನೋಡಿ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. 1 ಲಕ್ಷ ರೂಪಾಯಿ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದೀನಿ ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಮುಂದೆ.
ಅಲ್ಲ, ಅಷ್ಟು ಫೈನಾನ್ಷಿಯಲ್ ಕೆಪಾಸಿಟಿ ಇದೆ.
Please proceed.
ನಿಶಾನೆ ಬಿ 14ರ 3ನೇ ಪುಟದಲ್ಲಿ ದಿನಾಂಕ 14/8/2009 ಎಂಟ್ರಿ ಪ್ರಕಾರ ದಿ ಪೋಸ್ಟ್ ಮಾಸ್ಟರ್ ವಿಜಯನಗರ 4 ಲಕ್ಷ ರೂಗಳೆಂದು ಕಾಣಿಸಲಾಗಿದೆ ಎಂದರೆ ನಿಜ. ಸದರಿ ಎಂಟ್ರಿಯನ್ನು ನಿಶಾನೆ ಪಿ 14A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದೇ ರೀತಿ ನಿಶಾನೆ ಪಿ 14ರ ಕೊನೆ ಪುಟದಲ್ಲಿ ದಿನಾಂಕ 23/3/2010 ಎಂಟ್ರಿ ಪ್ರಕಾರ ಗರುಡಾ ಗೇರ್ಸ್ 5 ಲಕ್ಷ ರೂಗಳೆಂದು ಕಾಣಿಸಲಾಗಿದೆ ಎನ್ನುವುದು ಸರಿ. ಸದರಿ ಎಂಟ್ರಿಯನ್ನು ನಿಶಾನೆ ಪಿ 14B ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ ಪಿ 13 ಮತ್ತು 14ರ ಪ್ರಕಾರ ನಾನು ಒಟ್ಟು 12 ಲಕ್ಷ ರೂಗಳನ್ನು ಬೇರೆ ಬೇರೆ ಸಂಸ್ಥೆಗಳಲ್ಲಿ ಹೂಡಿಕೆ ಮಾಡುತ್ತೇನೆ ಅನ್ನುವುದು ನಿಜ. ನಾನು ಆದಾಯ ತೆರಿಗೆ ಮಾಡುತ್ತೇನೆ ಅನ್ನುವುದು ನಿಜ. In the earlier cross examination, my lord, he had stated that he had withdrawn 11,45,663 from his GPF account. So out of which, my lord, he had invested 12 lakh rupees in with 3 persons.
Now, how to correlate these two? I have withdrawn a particular sum of money, 11 lakh and all, at one statement at some place. Subsequent place, he has stated that, say, 12 lakh rupees I have totally invested in different financial companies, etc.
That amount was invested.
How do you say that the GPF amount withdrawn was invested in this company in cash?
But he did not
correlate between these two.
He did not had any other financial transactions in his account during those periods.
No, you should,
Exhibit
you should have
B13.
suggested the same. Have you elicited from him that the amount which you have withdrawn, which is the GPF amount in cash, that is the very same amount you have invested in different investments? The witness would have given his answer. Yes, no.
Further cross examination.
Yes. Then read it completely.
Please.
Then start interpreting it.
Please.
97,000 ಪೆನ್ಷನ್ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ ಈಗ ಕೂಡ.
ನಾನು ಆರೋಪಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು 6ನೇ ಪೇಜ್ 3rd ಲೈನ್. ನಾನು ಆರೋಪಿಗೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು ಹೇಳುತ್ತಿರುವ ಹಣವನ್ನು ನನ್ನ ಆದಾಯ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ತೋರಿಸಿರುವುದಿಲ್ಲ. ನಾನು ಆರೋಪಿಗೆ ಹಣ ಕೊಟ್ಟಿದ್ದ ಪಕ್ಷದಲ್ಲಿ ಅದನ್ನು ಆದಾಯ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ತೋರಿಸಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು GPF, ಗ್ರೂಪ್ ಇನ್ಶೂರೆನ್ಸ್, ರಜೆ ನಗದೀಕರಣ ಹಾಗೂ ಇತರೆ ಭತ್ಯೆಗಳನ್ನು ಸ್ವೀಕರಿಸಿದಾಗ ಅವುಗಳು ಆದಾಯ ತೆರಿಗೆಯಿಂದ ವಿನಾಯಿತಿ ಹೊಂದಿರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು ಆರೋಪಿಗೆ ಯಾವುದೇ ಹಣವನ್ನು ಕೊಟ್ಟಿಲ್ಲದ ಕಾರಣ ಅದನ್ನು ನಾನು ಆದಾಯ ತೆರಿಗೆ ರಿಟರ್ನ್ಸ್ ನಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ದಿನಾಂಕ 25/2/2021 ನಾನು ಆರೋಪಿಗೆ ಹಣ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅದರಲ್ಲಿ 1000 ರೂಗಳ ಮುಖಬೆಲೆಯ ನೋಟುಗಳು 5 ಬಂಡಲುಗಳು, 500 ರು ಮುಖಬೆಲೆಯ ನೋಟುಗಳು 9 ಬಂಡಲುಗಳು ಇದ್ದ ನಾನು ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿ ಮಾಡುವುದಿಲ್ಲ. ಆರೋಪಿಗೆ ಹಣ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದು ಹೇಳಲಾದ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಕ್ಕಳು ಹಾಜರಿದ್ದು ಅವರೇ ಹಣವನ್ನು ಲೆಕ್ಕ ಹಾಕಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿಯಿಂದ ಭದ್ರತೆಗಾಗಿ ಏನು ದಾಖಲೆ ಪಡೆದುಕೊಂಡಿದ್ದೀರಿ ಅಂದರೆ ಸಾಕ್ಷಿಯು ಆತ ನನ್ನ ಕೈಯಲ್ಲಿ ಆನ್ ಡಿಮ್ಯಾಂಡ್ ಪ್ರೊನೋಟ್ ಅನ್ನು ಬರೆಸಿ ತನ್ನ ಸಹಿ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಈ ಕೇಸಿನಲ್ಲಿ ಹೇಳುತ್ತಿರುವ ವ್ಯವಹಾರಕ್ಕೂ ಮೊದಲು ನನ್ನ ಮತ್ತು ಆರೋಪಿಯ ನಡುವೆ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ ನಡೆದಿತ್ತು. ಅದು ಯಾವ ವರ್ಷದಲ್ಲಿ ಅಂದರೆ 1994ರಿಂದ ಸೆಪ್ಟೆಂಬರ್ 2002ರವರೆಗೂ ಇರುತ್ತದೆ ಎಂದು. ಆದರೆ ಆ ಸಮಯದಲ್ಲಿ ಸದರಿ ಹಣಕಾಸಿನ ವ್ಯವಹಾರ 50,000 ರೂಗಳ ಮೇಲ್ಪಟ್ಟು ಆಗುತ್ತಿರಲಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ದಿನಾಂಕ 3/3/2010 ಆರೋಪಿ ನನ್ನ ಬಳಿ 1,70,000 ರೂಪಾಯಿಗಳು ಸಾಲ ಪಡೆದುಕೊಂಡಿದ್ದರು ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಖಾಲಿ ಪ್ರೊನೋಟ್ ಮತ್ತು ಖಾಲಿ ಚೆಕ್ಕಿಗೆ ಆರೋಪಿಯಿಂದ ಸಹಿಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P3 ನಾನೇ ಸ್ವತಃ ಬರೆದು ಆರೋಪಿಗೆ ಕೊಟ್ಟಿರುವ ನೋಟಿಸ್ ಅನ್ನುವುದು ನಿಜ. ಆರೋಪಿಯಿಂದ ನಾನು ಯಾವುದೇ ಬಡ್ಡಿ ಹಣ ಕೇಳಿಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಆರೋಪಿ 30 ದಿನಗಳೊಳಗಾಗಿ ಹಣ ವಾಪಸ್ ಕೊಡುತ್ತೇನೆಂದು ಹೇಳಿದ್ದು ಆ ಅವಧಿಯಲ್ಲಿ ಹಣ ವಾಪಸ್ ಕೊಡದೇ ಇರದ ಕಾರಣ ಆತ ತಾನಾಗಿಯೇ 1% ಬಡ್ಡಿ ಸೇರಿಸಿ ಹಣ ವಾಪಸ್ ಕೊಡುತ್ತೇನೆಂದು ಹೇಳಿದ್ದರು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ P1ರಲ್ಲಿರುವ ಕೈ ಬರಹ ನನ್ನದೇ ಇರುತ್ತದೆ. ಸಾಕ್ಷಿಯು ಮುಂದುವರೆದು ಆರೋಪಿ ತನಗೆ ಬರೆಯಲು ಬರುವುದಿಲ್ಲ, ನೀವೇ ಚೆಕ್ಕಿನಲ್ಲಿ ಬರೆದುಕೊಳ್ಳಿ ಎಂದು ಹೇಳಿದ್ದರು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ P1ರಲ್ಲಿರುವ ಸಹಿ ಮತ್ತು ಇತರ ವಿವರಗಳು ಇರುವ ಇಂಕಿನಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ನಾನು ಬರೆದಿರುವುದನ್ನು ನನ್ನ ಪೆನ್ನಿನಲ್ಲಿ ಬರೆದಿದ್ದು ಆರೋಪಿ ತನ್ನ ಪೆನ್ನಿನಲ್ಲಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ P6ರಲ್ಲಿರುವ ನನ್ನ ಬರವಣಿಗೆಯನ್ನು ಸಹ ನಾನು ದಿನಾಂಕ 3/3/2010 ಆರೋಪಿಗೆ 1,70,000 ರೂಗಳನ್ನು ಕೊಡುವಾಗ ಬರೆದುಕೊಂಡಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸದರಿ ದಾಖಲೆಗಳಲ್ಲಿ 1% ಬಡ್ಡಿಯಂತೆ ನೀವೇ ಬರೆದುಕೊಂಡಿದ್ದೀರಿ ಅಂದರೆ ಸಾಕ್ಷಿಯು ಆರೋಪಿ ಬರೆಯುವಂತೆ ಹೇಳಿದ್ದು ನಾನು ಅದನ್ನು ಬರೆದಿದ್ದೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಿಶಾನೆ P6ರ ಮೇಲ್ಭಾಗದಲ್ಲಿ ತಾರೀಖನ್ನು ನಾನೇ ತಿದ್ದಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿ. ನಿಶಾನೆ P6ರ ಹಿಂಭಾಗದಲ್ಲಿ ಹಣ ಸ್ವೀಕೃತಿಯಾಗಿದ್ದು ಅದರ ಸಂಬಂಧ ನಮೂದಾಗಿರುವ ವಿವರಗಳನ್ನು ನಾನೇ ಒಡೆದು ಹಾಕಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P6ರ ಸಂಬಂಧಿತ ಭಾಗವನ್ನು ಗುರುತಿಸುವಿಕೆಯ ಸಲುವಾಗಿ ನಿಶಾನೆ P6C ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ದಿನಾಂಕ 3/3/2010 ಆರೋಪಿ ನನ್ನಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದ 1,70,000 ರೂಗಳನ್ನು ಚೆಕ್ ಮೂಲಕ ಮರುಪಾವತಿ ಮಾಡಿದ್ದಾರೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P13ರಲ್ಲಿ ಚೆಕ್ ನಂಬರ್ 524096 ಆರೋಪಿ ನನಗೆ ಸದರಿ ಹಣವನ್ನು ಮರುಪಾವತಿ ಮಾಡಿರುವ ಬಗ್ಗೆ ನಮೂದಿಸಿದೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ಸದರಿ ಚೆಕ್ ಅನ್ನು ನನಗೆ ಬೇರೆ ಯಾರೋ ಕೊಟ್ಟಿರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು ಸೇವೆಯಿಂದ ಸಸ್ಪೆಂಡ್ ಆಗಿದ್ದ ಕಾರಣ ನನಗೆ 9,50,000 ರೂಗಳನ್ನು ಕೊಡುವ ಸಾಮರ್ಥ್ಯ ಇರಲಿಲ್ಲ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆರೋಪಿಗೆ ನಾನು ಕೇವಲ 1,70,000 ರೂಗಳನ್ನು ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. In order to substantiate my contention that I had availed a sum of rupees 1,70,000 from the respondent herein, I had repaid the said amount. I had produced exhibit D1 document. In the defense evidence of the petitioner herein, he had stated the two aspects with regard to financial capacity of the respondent herein, and he had availed a sum of rupees 1,70,000 from the respondent herein, and he had repaid this amount. While availing 1,70,000 from the respondent herein, at that point of time, he had executed certain documents. The respondent herein has misused those documents, and he had filed the complaint before the learned magistrate. That was the evidence of the petitioner herein. But in order to substantiate my contention that he had availed 1,70,000 and he had written that amount, my lord, he had produced the exhibit D1 document, bank statement of the petitioner herein.
When did you avail the loan of rupees 1.7 lakh?
Cross examination alli adannu kelidare. Page number 7, my lord. Page number 7 of cross examination. ಕೆಳಗಡೆಯಿಂದ 5ನೇ ಲೈನ್. ನಿಶಾನೆ ಬಿ 6ರಲ್ಲಿರುವ ನನ್ನ ಬರವಣಿಗೆ ಸಹ ನಾನು ದಿನಾಂಕ 3/3/2010 ಆರೋಪಿಗೆ 1,70,000 ರೂಗಳನ್ನು ಕೊಡುವಾಗ ಬರೆದುಕೊಂಡಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. On that date, my lord, that amount was availed from the respondent here. ಅದಕ್ಕಿಂತ ಮೇಲ್ಗಡೆ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲೂ ಇದೆ. ದಿನಾಂಕ 3/3/2010 ಆರೋಪಿ ನನ್ನ ಬಳಿ 1,70,000 ರೂಗಳನ್ನು ಸಾಲ ಪಡೆದುಕೊಂಡಿದ್ದರು ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ಆ ಸಮಯದಲ್ಲಿ ಒಂದು ಖಾಲಿ ಪ್ರೊನೋಟ್, ಒಂದು ಖಾಲಿ ಚೆಕ್ಕಿಗೆ ಆರೋಪಿಯಿಂದ ಸಹಿಗಳನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. For a moment, my lord, exhibit D1 may kindly be seen.
One moment.
Exhibit D1.
One moment.
One, sir. One day documented.
One moment.
Please.
Exhibit D1.
D1, my lord.
Yes.
First page of the passbook, my lord, reflects the name of the petitioner herein. Account holder Krishna Gowda GV. Krishna Gowda GV at the account holder name.
Yes.
Then, my lord, the next page, my lord, transaction dated the 3/12/2010. Transaction dated 3/12/2010. MS Lingaya. Check number so and so 1,70,000 ರೂಪಾಯಿ. Since my lord, 138 of Negotiable Instrument Act is a rebuttal evidence, my lord, I had rebutted the presumption. My lord, I had availed a sum of rupees 1,70,000 in the year 2010, and I had repaid this amount to the respondent hearing, for which I had produced a documentary evidence before the learned magistrate. With regard to the financial capacity of the respondent herein, if your lordship can peruse the statements of the respondent herein, which are produced at exhibit P13 and 14, claims that the amount was paid to the petitioner herein in the month of February 2011. If your lordship can peruse exhibit P12 and P13, right?
ಎಡೆ ಅಕೌಂಟ್ ಅಲ್ಲ, ಇನ್ನೂ ಬೇರೆ ಎಕ್ಸ್ಟ್ರಾ ಅಕೌಂಟ್ಗಳು ಇರ್ತವೆ. ಕೊಟ್ಬಿಟ್ರೆ ಅಷ್ಟೇ.
Exhibit P12. Exhibit P12, it is only of the year 2010. ಅದರಲ್ಲಿ ಎಲ್ಲೂ ಕೂಡ ಅವರ ಅಕೌಂಟ್ ಅಲ್ಲಿ 9,50,000 ರೂಪಾಯಿ ಎಲ್ಲೂ ಇದ್ದಂಗೆ ಎಕ್ಸಿಬಿಟ್ P12 ಅಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ. ಅದು ಎಕ್ಸಿಬಿಟ್ P13 ಒಂದ್ಸಾರಿ ತಾವು ನೋಡಿದ್ರೆ. So on certain occasions he had withdrawn the money. Exhibit P13 also. This transaction dated 3/12/2020. 3/12/2020 transaction ಅಲ್ಲಿ ನಾನು ರೀಪೇ ಮಾಡಿರುವಂತ ಚೆಕ್ ನಂಬರ್, ನನ್ನ ಬ್ಯಾಂಕ್ ನೇಮು, ನನ್ನ ಅಮೌಂಟ್ ಎಲ್ಲ ಇವ್ರ ಅಕೌಂಟ್ ಅಲ್ಲೂ ರಿಫ್ಲೆಕ್ಟ್ ಆಗುತ್ತೆ. ಲಾಸ್ಟ್ ಲೈನ್ 3/12/2010 ಚೆಕ್ ನಂಬರ್ 524096 ಬ್ಯಾಂಕ್ ಆಫ್ ಬರೋಡಾ 1,70,000 ರೂಪಾಯಿ ಇವ್ರ ಅಮೌಂಟ್ ಗೆ ಬಂದಿದೆ. The very check which I had given to the respondent herein, and he had encashed the said check. Cross examination ಅಲ್ಲಿ ಮಾತ್ರ ನನಗೆ ಆ ರೀತಿ ಯಾವುದು ಹಣ ರೀಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಫೆಬ್ರವರಿ 2011ರಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P13 ಪ್ರಕಾರ nowhere the respondent had sum of rupees 9,50,000 in his account, or else he had not even produced a single piece of paper before the learned magistrate in order to show that he had a sum of rupees 9,50,000 during the month of February 2011 with him. Since my lord, he is a central government employee, it has to be presumed that it is not his case that apart from his salary he has any other source of income. He even doesn't say anywhere that apart from his salary, he had any other source of income. Moreover, at that point of time, he was trapped by the CBI. A criminal case was registered against him, and he was even convicted in that case. Under that circumstance, statutory amount would have been paid to the respondent herein. He was not even getting a full salary at that point of time.
Would have produced the documents after obtaining it from the RTA. So they were claiming that they have filed a RTA application.
Yes.
For a moment, your lordship may kindly peruse exhibit P6. Adaralli Himbaga, there is a reference of rupees 1,70,000. Backside of exhibit P6. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅದನ್ನ ಬರೆದು ಹೊಡೆದಾಕಿದೀನಿ ಅಂತ ಒಪ್ಕೊಂತಾರೆ. ಹಂಗಾಗಿ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಮಾರ್ಕ್ಡ್ ಆಸ್ ಎಕ್ಸಿಬಿಟ್ P6C. 1,70,000 ರೂಪಾಯಿ ಬಗ್ಗೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದನ್ನ ನೆಗೆಟಿವ್ ಆಗಿ ಹೆಲ್ಡ್ ಆಗಿದೆ.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದ್ರ ಬಗ್ಗೆ ಎಕ್ಸಿಬಿಟ್ P6B ಬಗ್ಗೆ ರೆಲೆವೆಂಟ್ ಪೋರ್ಷನ್
ಪೇಜ್ ನಂಬರ್ 8 ಮೇಲೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೋರ್ಷನ್. ಪೇಜ್ ನಂಬರ್ 8. ನಿಶಾನೆ P6ರ ಮೇಲ್ಭಾಗದಲ್ಲಿ ತಾರೀಖನ್ನು ನಾನೇ ತಿದ್ದಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿ.
ಒಂದು ನಿಮಿಷ.
ಪೇಜ್ ನಂಬರ್ 8. ನಿಶಾನೆ P6ರ ಮೇಲ್ಭಾಗದಲ್ಲಿ ತಾರೀಖನ್ನು ನಾನೇ ತಿದ್ದಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿ. ನಿಶಾನೆ P6ರ ಹಿಂಭಾಗದಲ್ಲಿ ಹಣ ಸ್ವೀಕೃತಿಯಾಗಿದ್ದು ಅದರ ಸಂಬಂಧ ನಮೂದಾಗಿರುವ ವಿವರಗಳನ್ನು ನಾನೇ ಒಡೆದು ಹಾಕಿದ್ದೇನೆ ಅನ್ನುವುದು ಸರಿಯಲ್ಲ. ನಿಶಾನೆ P6ರ ಸಂಬಂಧಿತ ಭಾಗವನ್ನು ಗುರುತಿಸುವಿಕೆಯ ಸಲುವಾಗಿ ನಿಶಾನೆ P6C ಎಂದು ಗುರುತಿಸಲಾಯಿತು. There is reference with regard to repayment of 1,70,000 to the respondent here, which was avoided by the petitioner earlier.
Now, how that come to your aid? Your suggestion has been denied by him. That is
It has been
He has
denied.
not admitted that it was.
Whereas a reference has been there in the backside of exhibit P6 with regard to 1,70,000.
That was a mere your suggestion which has denied.
Please. That has been
A
denied.
denied suggestion you cannot take as an admitted fact.
Milord, a presumption has to be drawn.
How?
A presumption has to be drawn that since, Milord, I had repaid 1,70,000 as per exhibit D1, that has been reflected in the account statement of the respondent herein as per exhibit P13.
1,70,000 rupees transaction, fine. At one place at one place he has denied the same and another place he has admitted the receipt of the same, fine.
Please.
But some entries that has been struck behind a promissory note, how do you correlate that to this? You might have suggested to the witness that this is that entry with respect to that particular transaction. Witness has categorically denied the same.
My submission for that is, since the petitioner had repaid that 1,70,000 which he had borrowed from the respondent, he had made entry behind the exhibit P6. That is my submission.
Sir, that is your imagination. There is a difference between an inference and an imagination. Can an inference be legally drawn by virtue of that evidence and exhibit P6C that promissory note was what with respect to 1,70,000 only and entry was made and cancelled?
Please. With regard to that, Exhibit D1 and Exhibit P13 are correlating documents.
That you said, exhibit P13 is with
and-
respect to 1,70,000 transaction. If you had really paid, say, 1 lakh, repaid 1,70,000 rupees, you should have asked him, cancel the entry on the face page of the demand promissory note. Why on the back side? Of course, he did not give you the promissory note despite your request.
Please.
But you yourself is telling that this entry is with respect to 1,70,000 rupees. As such, after repayment, he has cancelled it. Then, if you are so prudent and getting it cancelled, you should have ensured the cancellation on the front side, facial sheet of the demand promissory note.
It is the case of the respondent that, my lord, while taking an amount of rupees 1,70,000, he had only put his signatures on that exhibit P6 and the disputed check. Apart from that,
Exactly, Mr. Counsel. ನಾನು ಇದನ್ನ ಹೇಳಿದ್ರೆ ಇನ್ನೊಂದು ಜಂಪ್ ಆಗ್ತಾರೆ, ಇನ್ನೊಂದು ಜಂಪ್ ಆಗ್ತಾ ಇದ್ದೀರಿ. ನಿಮ್ಮ ಪ್ರಕಾರ ಎಕ್ಸಿಬಿಟ್ P6C ಅನ್ನೋದು 1,70,000 rupees ಎಂಟ್ರಿ ಬರೆದದ್ದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ಯಾಕೆಂದ್ರೆ ನಾನು 3rd December 2010 ಗೆ ನಾನು ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ಕೊಟ್ಟಿದ್ರಿಂದಾಗಿ ಆ ಎಂಟ್ರಿನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೀವು ಅದನ್ನ ನೀವು this is the entry that was cancelled and therefore that was the only transaction ಅಂತ ನೀವು ಹೇಳುವುದು. ಆ ರೀತಿ ನೀವು ಹೇಳುವುದು. ಆ ಕ್ಯಾನ್ಸಲೇಷನ್ ಬದಲು ನೀವು ಸ್ವಾಮಿ ನಾನು ಸೈನ್ ಹಾಕಿರೋದು DPN ಫ್ರಂಟ್ ಸೈಡ್ ನಲ್ಲಿ, ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇದನ್ನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸ್ಬೇಕಿತ್ತಲ್ವೇ? ಅವ್ರು ನಿಮಗೆ DPN ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೂ ಸರಿ, DPN ಗೆ ಸೈನ್ ಹಾಕಿರೋ ಜಾಗ ನೀವು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸ್ಬೇಕೆ ಹೊರತು ಬೇರೆ ಯಾವುದೋ ಒಂದು ಕ್ಯಾನ್ಸಲ್ಡ್ ಪೋರ್ಷನ್ ಇದೆ ಅಂತ ಮಾತ್ರಕ್ಕೆ ಅದು 1,70,000 ರಿಪೇಮೆಂಟ್ ಇಂದ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಿಮಗೆ ನೀವೇ ಅದಕ್ಕೊಂದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಕೊಟ್ರೆ ದಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಇಮ್ಯಾಜಿನೇಷನ್ ಬಟ್ ನಾಟ್ ಇನ್ಫರೆನ್ಸ್.
ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸ್ವಾಮಿ ಇಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಏನಂದ್ರೆ, CBI ರೈಡ್ ಮಾಡಿದ್ಮೇಲೆ ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಬೇರೆ ಎಲ್ಲೋ ಇಟ್ಟಿದ್ದೀನಿ. ಸೊ ಹಂಗಾಗಿ ಈ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ನನ್ನ ಹತ್ರ. So as soon as I get the documents, I would return those documents ಅಂತ ಸಜೆಷನ್ ಕೂಡ ಮಾಡಿದ್ರು.
ಎಲ್ಲಿದೆ CBI ಅದೊಂದು ಅದು ಇದು ಮಾಡ್ಕೊಂಡು ಅದನ್ನೇ ದೊಡ್ಡ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Case is pending before the falsely trapped.
That has been said in the chief examination of RW.
CBI ರೈಡಿಗೂ ಈ ಲೋನ್ ಆಗಿದೆ ಅಥವಾ ಆಗಿಲ್ಲ ಅನ್ನೋದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
CBI ಕೇಸ್ ಅನ್ನು ಏನಕ್ಕೆ ಇದಕ್ಕೆ ಲಿಂಕ್ ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ, he was not getting full salary which he was getting earlier. Ride ಆದ್ಮೇಲೆ he was suspended. Only 50% of salary was being given to him. ಆ ಕಾರಣಕ್ಕಾಗಿ CBI ಕೇಸ್ ಅನ್ನು ಅದಕ್ಕೆ ಲಿಂಕ್ ಮಾಡಿದ್ರು.
ಅವ್ರನ್ನ 75% ಸ್ಯಾಲರಿ ಬರ್ತಾ ಇತ್ತು ಅಂತ ಹೇಳಿದ್ದಾರೆ, ನೀವು ಅದನ್ನ ಡಿನೇ ಮಾಡಲಿಲ್ಲ.
ಈ ಕೂಡ ಪ್ರೊಡ್ಯೂಸರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
75% ಸ್ಯಾಲರಿ ಬರ್ತಾ ಇತ್ತು ಅಂತಾರೆ, ಡಿನೇ ಮಾಡಲಿಲ್ಲ ನೀವು ಅದನ್ನ. ಹಾಗಾಗಿ CBI ಆಗಿ ಸಸ್ಪೆಂಡ್ ಆದ್ರೂ ಕೂಡ ಎಷ್ಟು ಬರ್ತಾ ಇತ್ತು ಸ್ಯಾಲರಿ ಅದನ್ನ 75% ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ. ಈಗ ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ಅದು ಎಷ್ಟೇ ಸ್ಯಾಲರಿ ಬರಲಿ, ಇಟ್ ವಾಸ್ ಥ್ರೂ ಅಕೌಂಟ್. ಅವ್ರ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಸ್ಯಾಲರಿನ ಕ್ಯಾಶ್ ಕೊಟ್ಟು ಸೈನ್ ತಗೊಳ್ಳಲ್ಲ. ಹಾಗಾಗಿ ಅದು ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಗಳಲ್ಲಿ ರಿಫ್ಲೆಕ್ಟ್ ಆಗ್ಲೇಬೇಕು. ಅವರೇ ಹಾಕಿರ್ತಕ್ಕಂಥ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಯಾವತ್ತು ಸಾಲ ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಆ ಸಾಲ ಕೊಡುವ ದಿನಾಂಕದೊಂದು ಅವರ ಬ್ಯಾಂಕ್ ಬ್ಯಾಲೆನ್ಸ್ ನಲ್ಲಿ ಅಷ್ಟು ಹಣ ಇಲ್ಲವೇ ಇಲ್ಲ. ಅವರು ಬ್ಯಾಂಕ್ ಬ್ಯಾಲೆನ್ಸ್ ನಲ್ಲಿ ಕೇವಲ 15,000 ಚಿಲ್ಲರೆ ಇದೆ, 15,926 ರೂಪಾಯಿ 42 ಪೈಸೆ ಹೇಳಿದ್ದಾರೆ, ಅಷ್ಟು ಮಾತ್ರ ಇದೆ. ಉಳಿದಿದ್ದು ನಾನು ಮನೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಉಳಿದ ಹಣ ನನ್ನ ಮನೆಯಲ್ಲಿ ಇತ್ತು, ಐ ಹ್ಯಾಡ್ ಸಫಿಶಿಯಂಟ್ ಮನಿ ಇನ್ ದಿ ಫಾರ್ಮ್ ಆಫ್ ಕ್ಯಾಶ್ ಅನ್ನೋದನ್ನ ನಿಮ್ಮ ಪ್ರಕಾರ ಅವ್ರು ಹೇಳ್ಬೇಕಾಗುತ್ತೆ. ನಿಮ್ಮ ಪ್ರಕಾರ ಅವರು ಅದನ್ನ ಹೇಳಿಲ್ಲ. ಸಮ್ಮರಿ ಆಫ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ. ಅದಕ್ಕೆ CBI ವರೆಗೂ ಹೋಗ್ಬೇಕಾದ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಒಬ್ಬ ವ್ಯಕ್ತಿ ಮೇಲೆ CBI-ನೋ ACB-ನೋ ಏನೋ ರೈಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ ಕೂಡಲೇ ನೀವು ಯಾವುದನ್ನ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಬಿಡ್ತೇನೆ ಅನ್ನೋ ಅಟೆಂಪ್ಟ್ ಮಾಡೋದು ಬೇಡ. ಇಲ್ಲಿ ಆಂಬಿಟ್ ವೆರಿ ವೆರಿ ನ್ಯಾರೋ, ವೆರಿ ವೆರಿ ನ್ಯಾರೋ. He had every opportunity to demonstrate before the court about his financial capacity to lend, since he was admittedly a central government gazetted officer. He was expected not to have any other source of income. Admittedly has not declared any other source of income. If at all any of his source of income were to be there, they were only in the form of a salary. The salary used to be paid to him only through the bank account. He being the master of his bank account, he ought to have produced the bank account statement, which has failed to do.
Please.
The bank accounts passbooks of the statement, what he has produced by himself, does not reflect his financial capacity. ಅಷ್ಟೇ ಅಷ್ಟು ಸಮ ಪ್ರಿಸೈಸ್ ಆಗಿ ಅಷ್ಟನ್ನ ಇಟ್ಬಿಡ್ಬೋದು. ಅದು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಇನ್ನೇನೋ ಹೇಳಿ ನಾನು ಅದನ್ನ ತೋರಿಸ್ತೇನೆ, ಇದನ್ನ ತೋರಿಸ್ತೇನೆ, ಎಕ್ಸಿಬಿಟ್ P6 ತೋರಿಸ್ತೇನೆ, ಏನೋ ದೊಡ್ಡದಾಗಿ ನಾನು ಭೂತ ಇಡ್ತೇನೆ. ಅಲ್ಲ, ಸಣ್ಣದ ದೀಪದಿಂದ ಬಂದು ಹುಳಾದ್ರೂ ಕೂಡ ಭೂತದಷ್ಟು ಶಕ್ತಿ ಇದ್ರೆ ಅದೇ ಕೆಲಸ ಮಾಡುತ್ತೆ.
ಅಲ್ಲ, ನಾನು ಮೊದಲಲ್ಲೇ ಅದಕ್ಕೆ ಹೇಳ್ಬಿಟ್ಟೆ ಸರ್, ನಾನು 2 ಗ್ರೌಂಡ್ ಮೇಲೆ ಅಕ್ವಿಟಲ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲೇ ಹೇಳಿ.
That is all.
Please.
Yes, proceed.
Yes, sir. In this case, check is also admitted. Apart from even on-demand promissory note is also admitted by the accused.
No, where he has admitted the execution of on-demand promissory note, you are concluding straight away that on-demand promissory note is also admitted.
Admitted, what the contention is.
Sir, it is a court of law. You should convince me. What it comes to admission, he has been throughout disputing demand promissory note. Also the check.
My lord, in this
His case is that he has misused them. Therefore, the question of admission does not have it.
My lord, in this case, there was a delay of 8 days.
That is over. No, you cannot contend. Neither of you can contend that point.
In this case, at the time of the delay, condoning the delay, accused was given an opportunity to cross-examine the PW1. During the cross-examination, he took the contention that page number at pre-cognizant stage, accused took the contention that ನಾನು ಆರೋಪಿಗೆ ನೋಟಿಸ್ ಕಳಿಸೋದಕ್ಕಿಂತ ಮೊದಲು ಮತ್ತು ನಂತರ ಆರೋಪಿಗೆ ನಾನು ಕೊಡಬೇಕಾಗಿದ್ದ ಹಣವನ್ನು ಪೂರ್ತಿಯಾಗಿ ಮರುಪಾವತಿ ಮಾಡಿದ್ದಾರೆ ಅಂದರೆ ಸರಿಯಲ್ಲ.
Exactly. He does not deny the alleged loan transaction between you.
Yes, my lord.
Both of them. He says, yes, I was borrowing money, but I have never borrowed 9,50,000 rupees.
Another aspect is
maximum amount I have borrowed was 1,70,000 rupees.
Yes, my lord.
Which I have paid.
Here, another aspect is there. According to his ಆರೋಪಿಗೆ 2 times his contention is ಆರೋಪಿಗೆ ನೋಟಿಸ್ ಕೊಡಿಸೋದಕ್ಕಿಂತ ಮೊದಲು ಮತ್ತು ನಂತರ 2 times according to accused he has paid twice. One is, even if it is accepted, it is 1,70,000, it is one time. That is, what about other notice ಕೊಡೋದಕ್ಕಿಂತ ಮುಂಚೆ? ಇಲ್ಲಿ 2 ತರ ನಾನು ಆರೋಪಿಗೆ ನೋಟಿಸ್ ಕೊಡಿಸೋದಕ್ಕಿಂತ ಮೊದಲು ಮತ್ತು ನಂತರ ಆರೋಪಿಗೆ ನಾನು ಕೊಡಬೇಕಾದ ಹಣವನ್ನು ಪೂರ್ತಿಯಾಗಿ ಮರುಪಾವತಿ ಮಾಡಿದ್ದಾರೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ತನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಯಿಂದ ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಹಣ ಜಮಾ ಮಾಡುತ್ತಿದ್ದರು ಅಂದ್ರೆ ಸರಿಯಿಲ್ಲ. ಆರೋಪಿ ಪೂರ್ತಿ ಹಣವನ್ನು ಮರುಪಾವತಿ ಮಾಡಿದರೂ ಸಹ 2 ಸುಳ್ಳು ಕಾರಣ ಕೊಟ್ಟು ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. That means, ಈಗ next they have improved. At the first stage that took the contention that ಆರೋಪಿಗೆ ನೋಟಿಸ್ ಕೊಡೋದಕ್ಕಿಂತ ಮೊದಲು ಒಂದು ಸರಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದಾದ ನಂತರ ನೋಟಿಸ್ ಆದ ನಂತರ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ. ನಾವು after the ಇದಾದ್ಮೇಲೆ only one contention 1,70,000. Another important aspect in this case is ಇವ್ರು ಹೇಳ್ತಾರೆ 3/12/2010 3/3/2010 ಚೆಕ್ ನ ಸಾಲ ತೆಗೆದುಕೊಂಡಾಗ ಚೆಕ್ ನಂಬರ್ 5,57,332 ನ್ಯೂಮರಿಕಲ್ ನಂಬರ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. 5,50,000. ಅದು ಇನ್ನೊಂದು ಪ್ರಶ್ನೆ ಕೇಳಿದೀನಿ ಅವ್ರಿಗೆ, ಯಾವ ರೀತಿ ಚೆಕ್ ಅಂದ್ರೆ 10 ಅಥವಾ 20 ಕೊಡ್ತಾರೆ, ನ್ಯೂಮರಿಕಲ್ ಸೀರಿಯಲ್ ಪ್ರಕಾರ ಇರ್ತದೆ, 1 2 3 4 5 ಈ ತರ ಹೋಗ್ತದೆ ಚೆಕ್ಗಳೆಲ್ಲ. ಇಲ್ಲಿ 3/3/2010 ಇವರು 5,57,335 ಚೆಕ್ ನ ಆ ನಂಬರ್ ನ ಚೆಕ್ ಕೊಡ್ತಾರೆ. 3/12/2010 ಸಾಲ ತೀರಿಸಬೇಕಾದ್ರೆ 3/12/2010 5,24,524,96 ನಂಬರ್ ಇಂದ ಚೆಕ್ ಕೊಡ್ತಾರೆ. ಅದು ಅದರ
ನೀವು ಅದನ್ನ ಯಾವ್ದನ್ನ ನೋಡಿ ಓದ್ತಾ ಇದ್ದೀರಿ? ಕ್ಯಾನ್ ಯು ಡ್ರಾ ಮೈ ಅಟೆನ್ಷನ್ ಟು ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೋರ್ಷನ್?
ಇಲ್ಲ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದಿ DW1.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್
DW1 ಕೃಷ್ಣೇಗೌಡ ಮೊದಲನೇ ಪೇಜ್ ಇದ್ರದ cross examination of DW1. May I read it?
Cross examination of DW1. There appears to be a lengthy cross-examination.
All are very important in this case. Just relevant portion is, I will read out. I might have been doing the check transaction since 2005, 2006. I have 3 accounts in 2 banks. One is the Bank of Baroda and the other 2 is the SBI. Both of them are SBI accounts. Apart from the security work, I was not doing any other work. It is true to suggest that I was working as a chowkidar in Foreman Training Institute, which was central government employment. It is true to suggest that before joining the said service, I was serving in the army. I do not know that before I joined the service as a chowkidar in the Foreman Training Institute, the complainant was working as a senior non-commissioned officer in the Indian Air Force. After the complainant retired from the said service, he joined the foreman. Question: after the complainant retired from the said service, he joined the Foreman Training Institute through the UPSC. Answer: as on the date of my joining the said institute, he was already working there. Page number 2. It is true to suggest that my immediate official supervisor was hostel warden in the said institute, and above him there was a superintendent. It is true to suggest that hostel warden had authority to grant the leave, compensatory off, and OT to me. It is true to suggest that while serving the said institute, I was also a member of the Central Staff Association of Employment and Training. It is true to suggest that I was also a secretary to this association. He is not only a common man, layman, Your Honor, lay chowkidar. He is a secretary to that association. Our Sanghakke secretary agirtare. Your mamuli not an ordinary secretary man. It is true to suggest that only after completion of the check leaves, a new checkbook will be issued by the bank. Checkbook it is false to suggest that I have deposited falsely in the para 5 of my affidavit that I have given the check in question as signed by the blank check to the complainant on 3/3/2000 only for the purpose of security. It is false to suggest that as on 3/3/2010, I was not in possession of the check in question since the same was issued by the from my bank in my favor as on the date. I can produce a document to show that as on the date of 3/3/2000, I was in possession of the check in question. It is important question. ಈಗಲೂ ಕೂಡ 3/3/2010ಕ್ಕೆ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಚೆಕ್ ನ ಸೆಕ್ಯೂರಿಟಿ ಆಗಿ ಕೊಟ್ಟಿದ್ವಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅವರು ಲೆಟ್ ದೆಮ್ ಪ್ರೊಡ್ಯೂಸ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ ಟು ಶೋ ದಟ್ ಆನ್ 3/3/2010 ದಟ್ ಚೆಕ್ ವಾಸ್ ಇನ್ ದೇರ್ ಪೊಸೆಷನ್. ಅದನ್ನ ಅವತ್ತು ಇದೇ ಕೇಳಿ ಅದನ್ನ ಇದು ಚೆಕ್ ನಂಬರ್ 55,000 ಇರೋದು. They were not unable to prove 3/3/2010 that serial number check was not there, was not in their possession. That is they were unable to. Our condition 3/3/2010 ಚೆಕ್ ನಂಬರ್ 5,52,335 ನಂಬರ್ ಇದೆ. Check number 3/3/2010. Both the checks belong to same bank. 3/3/2000. According to the accused, they gave one check bearing number 5,52,350 for availing a loan of 1,70,000. Availing 1,70,000. 5 lakhs. According to their case, on 3/12/2010, they repaid it by check number 5,24,096. 3/12/2010ಕ್ಕೆ ಚೆಕ್ ನಂಬರ್ 5,24,096 ಚೆಕ್ ನಂಬರ್. ಅದು ಒಂದು ಚೆಕ್ ಲೀಫ್ ಅಲ್ಲಿ 5 ಅಥವಾ 10 ಇರ್ತದೆ. ಟೋಟಲ್ ಡಿಫರೆನ್ಸ್ 27,926 ಚೆಕ್ ಹೇಗ್ ಬಂತು ಇವ್ರಿಗೆ? ಒಂದು ಚೆಕ್ ಇಲ್ದೆಲ್ಲ ಇನ್ನೊಂದು ಚೆಕ್ ರಿಲೀಸ್ ಮಾಡೋದಿಲ್ಲ ಅವರು.
What is the check number of rupees 1.7 lakh said to have been given by you to him to clear the loan?
That is a 524096, my lord. 524096. 3/12/2010. It was actually, as per the case of the accused, it was returned through the bank by way of check. 524096.
To show that as on the alleged date of you availing a loan of rupees 1.7 lakh, you were in possession of a blank check at exhibit P1. What is your evidence?
There's nothing. They were not able to produce any document. There was a specific question during the cross examination. In spite of that, they were not able to.
How do you overcome the said suggestion
Even
put to you that as on the said date of alleged transaction of 1.7 lakh loan, you are not in possession of the check at exhibit P1?
I did not produce any evidence. Not even
So
any.
how do you overcome his point in your cross examination? You didn't have that check on that particular day when you borrowed a loan of rupees 1.7 lakh. Therefore, the question of you giving the check at exhibit P1 as security does not arise. That's what his argument is.
Please.
He refers to a particular portion of the evidence in your cross examination.
There is no evidence with regard to that.
This theory is developed afterwards. First instance, at the time of cross examination, they were notice ಕೊಡೋದಕ್ಕಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿದ್ದೆ, ಮತ್ತೆ ನಂತರ ಕೊಟ್ಟಿದ್ದೆ ಅಂತ 2 ಸಾರಿ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಬರ್ತಾ ಒಂದೇ ಇದು 1,70,000 ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾಗ ನೋಡಿದ್ರು 1,70,000 ಬಂದಿದ್ದು. ಅದಕ್ಕೆ ಇಂಪ್ರೂವ್ಡ್ their case. Continuation. Further. Yeah. Capacity, regarding capacity, he is getting 2 pension, my lord. Even today, he gets one as a senior non-commissioned officer, another as a director of retired director of ministry of 90,000 as of today is getting pension. I have produced document. I can't discuss it from the service. False case, in a false case, he is trapped because he was a strict officer.
Serial number? Yes. No, we will see when the matter reaches. Probably it will reach today.
He's alive. Next week, next not saying that
2012 matter vakil re. 2011 2012 adjournment ಕೊಡ್ತಾ ಇಲ್ಲ ನಾನು. ನೋಡುವ ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ ನೋಡು. ಮ್ಯಾಟರ್ ರೀಚ್ ಆದಾಗ ನೋಡು.
Serial number 42. It is all the matter between the parties settled. Number 42. 42, my lord. The matter has been settled.
Santosha.
File a memo to dispose of.
Memo for what?
Memo for the settlement. Both the parties have agreed, and it has been
what
settled.
What is the offense?
138 must be.
138. ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ರೀಚ್ ಆಗುತ್ತೆ. ರೀಚ್ ಆದಾಗ ಹೇಳಿ. ವೆದರ್ ಮೆಮೋ ಇಸ್ ಅಕ್ಸೆಪ್ಟಬಲ್ ಅನ್ನೋದನ್ನು ಒಮ್ಮೆ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
ಯಾರು ಹುಡುಗನ ಹೆಸರು Court officer.